Be ready.
Court reporter's ready.
All right. Okay, it looks like we are streaming and recording, and I've got 9 o'clock. So this is Chair French, and I am convening the third day of the evidentiary hearing in this proceeding, and we are on the record. At this time, I believe we are ready for staff. Oh, I think actually we received an indication that a party would like to raise preliminary matters. So if there are any preliminary matters the parties wish to raise, now is the time.
Chair French, this is Jim Sikora. May I please be recognized to raise a preliminary matter?
Yes, please proceed.
Pursuant to KAR 82-1230, which incorporates the rules of evidence of chapters 4 of Kansas statutes, I would like to please request that the commission take judicial notice of 3 orders. And if I might please read them into the record, if it's okay with the chair.
Yes, please proceed.
The first item, number 1, is KCC docket number 24GIME-102-GIE. And that is an order dated January 23, 2025, titled Order Adopting Guidelines for Transmission Line Siting Criteria and Priorities. I would call to the commission the fact that I believe this is a January 23, 2025 order. There are 2 dates in the order. One is 26, I believe, to be an error. The second item, please, is KCC docket number 24-GBEE-790-STG. And that is order dated December 12, 2024, titled Order Approving Oil and Gas Protocol. The third item, please, if I might say, the third item, the second item, which is the order approving it, approves what I'm going to read in as the third item, okay? And the third item is KCC docket number 24-GBEE-790-STG- notice dated November 15, 2024, titled Notice of Filing of Grainbelt Express LLC Oil and Gas Protocol. And the second item that I sought judicial notice of simply adopts the third item. Okay, so I would please request that the commission take judicial notice of those 3 items so that we can, in our briefs, refer to those items without separately authenticating, and so that we may refer to those items in examination today.
Very well. Well, the commission freely takes note of its own files and records, but I will ask at this time if any party objects or wishes to respond to that request. All right, hearing no response, the 3 noted items, which I think were properly identified for the record so that parties can go find those on the commission's website, those will all be taken notice of and be part of the official record of this proceeding. Oh, go ahead.
May I please add one item, Chair French? I did send notice at about noon yesterday to all the parties that I was going to offer this or was going to reference these 3 items. So hopefully everybody received that notice and has them available to them.
I know I received an email from the pre-hearing officer letting me and the other commissioners know. So I presume the parties received that as well.
Thank you.
All right, thank you very much. Are there any other preliminary items the parties wish to take up before we resume examination of the witnesses?
Yes, good morning, Chair French. Can you hear me?
I can. Is this Ms. Hain?
This is.
Okay, go ahead. You're identified as Mr. Lateef, I think, but but I can tell.
This is Ms. Hain. We just have one preliminary matter. Over the weekend, staff distributed a copy of staff hearing exhibit 1. And that has been distributed to council for all parties. I think the presiding officer also distributed to the commissioners. So I would move to enter staff hearing exhibit 1 into the record at this time.
is there any objection to staff's motion?
Yes, Chairman French. The oil and gas intervenor object to this exhibit. It was not previously filed with testimony, and it is being introduced after the affected witness has already testified and been dismissed. Admission at this stage would be prejudicial because the operators whose leases are depicted is no longer available for examination. It would deprive the parties of the opportunity to examine the witness regarding the information shown. This exhibit lacks, I think it's a lack proper foundation. I don't see it's going to be authenticated. There's been no test. I don't think there can be any testimony regarding who prepared the maps, what data source was used, and whether it accurately reflects the location of the leases and the prepared route shown on that. I don't see the relevance, the purpose to my client has this is contrary to his direct testimony. There's no basis, in fact, for this. It may be misleading for testimony. It reflects oil and gas operations along the route if it's correctly depicted. However, this is based off an exhibit on a public comment. In fact, my client has additional leases along the route that were not listed in that public comment. I think it's for those reasons, we request that this is not admitted at this time.
Yeah, understood, Mr. Buck. Any response, Ms. Hain?
Yeah, PCC staff prepared this exhibit based on the direct testimony that was filed by Paul Buck in the record prior to this hearing. They used the legal description of the land that was contained in Mr. Buck's direct testimony to create this exhibit. And staff believes it's relevant to the proceedings because staff believes that there are outstanding questions about the extent of the effect of this proposed line on the oil leases on Mr. Buck's property. So staff's intention was to provide this illustration to kind of guide any questions that might still exist today after the first 2 days of the hearing.
Okay.
Well,
I'm prepared to rule on it. I'm going to deny the motion to admit the exhibit. I don't find there has been foundation laid for it. But what I will say is if there are questions relevant to this that open the door well, I don't presume to know which of staff's witnesses would have knowledge of this, but if there are questions relevant and staff wishes to raise it as a rebuttal exhibit, I suppose we could take it up then to see if there is any foundation that can be laid. But at this time, I'll deny the motion. All right. Are there any other preliminary items? Okay. Hearing none, staff, I believe we are ready for you to call your first witness.
Good morning.
Good morning.
Sorry about that.
Okay,
Good morning,
we've got you
staff.
now.
Good morning. Staff calls Leo Hanos to the stand.
All right, Mr. Hanos, are you with us?
I think I am. Can you hear me okay?
We can hear you. Okay, I'm going to have the court reporter swear you in now.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you.
Good morning, Mr. Hanos.
Morning.
Will you please state your full name for the record?
My name is Leo Hanos.
Who is your employer and what is your title?
I'm employed by the Kansas Corporation Commission Utilities Division as a utilities engineer.
Are you the same Mr. Hanos who filed direct testimony in this docket on January 29th?
I am.
Do you have any corrections or changes to make to your testimony at this time?
I do not.
Mr. Hanos' testimony has already been entered into the record, and so with that, I tender the witness for commission questions and cross-examination.
All All right, thank you, Ms. Hain. We will begin with commissioner questions, and we will start with Commissioner Keen, if you have any questions. Oh, and a quick reminder, I see a number of people with your microphones on. Just a reminder, since we're doing this on Zoom, if you're not scheduled to speak, go ahead and mute your microphones so we don't get background noise. And just, yes, talk when you're scheduled to talk. If anybody has a technical issue, we will go off the record to resolve it. But yeah, with that, I think, my apologies, Commissioner Keen. Why don't you go ahead and proceed?
No problem. Thank you, Chair French. Good morning, Leo.
Morning.
Can you hear me all right?
It's a little soft, but I think I can make it out.
Can you hear me better?
That's a little better, yes, sir.
If necessary, I can certainly take down the video portion. In fact, let's give that a shot here and see how that see if that impacts this any.
You're coming through loud and clear now, sir.
Oh, okay, very good. Leo, looking at your direct pre-filed testimony, is it fair to conclude that KCC staff is concerned that many active oil and gas operators along the proposed and preferred route were not contacted by Evergy?
I believe that's true, yes.
Explain that concern and the scope of it, if you would.
Well, the one oil and gas operator that I spoke with was Val Energy, and he brought up comments, I believe, at the Winfield open meeting, and because of that, I called him and talked to him about his concerns at that time, based on his public comments. And after that, of course, I looked through the Kansas Geological Survey's records, and you can see that this line is going to go through several areas that show oil and gas production on their interactive mapping system they have on their website. So because of that, I included that comment that said, well, we've talked to one owner. I think we can work through his situation after talking to him for extended time about his operation, how he was developing the field, what his future drilling program was going to be. But I pointed out that there are probably others, or maybe others, that we aren't aware of.
Okay, that's fair enough. And the research you did through the KGS website, did that take very long?
No, it didn't. You can pull up that map, and you have to know your section of townships and ranges too. That's how it's sort of developed. But once you know that, you can look at where the wells are pretty easily, and then compare them to the mapping route. We also looked at our own database and compared it to the Flint Hills moratorium area to see how many oil and gas wells are in the moratorium area as well.
Is there any evidence in the record that Evergy of its own accord conducted such an independent inquiry?
I believe last week in testimony, Burns and McDonald, which was the consultant that developed the routing survey, said they had spoken with outside, they had subcontractors that had looked at all available databases with the state. So I was giving their expertise, and assuming their subcontractor knew where to look, I'm sure that this was addressed, but it was not explicitly stated.
I want to take a look at page 7 of your direct testimony. In particular, I'm looking at lines 5 through 14. And for the benefit of all the parties present here this morning, I will read into the record the contents of that part of your pre-filed testimony. Should I misstate it, I would appreciate any corrections that you could make to that effort. The question that Leo's response is to request an explanation of the requirements in the 24102 docket regarding the contacting of oil and gas interests that are affected by the route. His response, beginning on line 5, is as follows. In my opinion, comma, the 24-102 order incorporates by reference the oil and gas industry protocols that were filed in docket 24-GBE-790-STG as minimum requirements, period. These protocols state the utility proposing a new transmission line will perform the following during the routing study phase of the project. And I'm going to interrupt my quoting from Leo's testimony to ask you a question at this point, if I may, Leo. This routing study phase of the project, does that occur before the siting of the line?
It is the siting of the line. Yes, it does. I'm sorry. The routing study would be the study that was done by Burns and McDonnell in this case, and then it's incorporated into the procedure we have today.
So in accordance with the protocols set forth in the cited docket for oil and gas, the routing study precedes the siting of the line. Is that correct?
That's correct.
I'm going to go back now and continue my quotations from Leo's testimony. Again, we're on page 7. I'm going to take up with line 9. And this is a follow on to, well, I'm going to start again with line 6. I'm sorry. So there's a prelude to this. On line 6, it says, these protocols state the utility proposing a new transmission line will perform the following during the routing study phase of the project. Then on to line 9, capital A, period. During the routing study phase of the project's development, the utility, will seek to identify existing oil and gas production infrastructure on the parcels within the study area, period. And then B, capital B, period. When developing a potential route network, the utility will, comma, to the extent feasible, comma, avoid routing transmission line segments that include existing above ground oil and gas infrastructure within the right of way, period. That's on line 14. Leo, have I adequately restated your testimony?
Yes, you have.
So if I'm understanding your testimony, it's contemplated both of these phases that are to be accomplished during the routing study phase of the project are inferentially supposed to be basically performed before the siting of the line. Is that not correct?
That's correct.
Now let's move now again. I want to quote some of your pre-filed testimony. I'm moving to page 8, lines 1 through 3. I'm beginning with the first full sentence on line 1. It reads as follows. However, there is evidence of considerable oil and gas activity along the entire proposed route, and there may be other active oil and gas leases that are impacted by the route that we are not aware of, period. Have I correctly quoted that, Leo?
Yes, you have.
Again, what gave you reason to believe that that was the case? That there were other active leases that you use the generic we, you can explain what that is, that we were not aware of. Do you mean staff and Evergy?
In my case, I mean staff. I can't speak for Evergy, but
Fair enough.
when we were looking through, again, from taking into consideration the comments from the public meetings, we didn't see any reference particularly to oil and gas infrastructure discussed in the Burns and McDonald study. However, as I noted earlier, in testimony last week, they did state that they had someone that did look for that. But we didn't see that. We were concerned as far as how this line could be routed through those areas. And I mentioned when I spoke with the gentleman from Val Energy, I think his biggest concern was that he was under the understanding that Evergy would require an additional setback beyond the 175-foot right of way. And I think once he understood, in fact, they do not require that. They don't even have a construction right of way beyond the 175-foot right of way. So I think once he understood that, he seemed to be a little more at ease that this could be worked out between him and Evergy. I didn't get into how to work it out. That would be something he has to discuss with them. But after discussing his drilling operations, it seemed like being able to drill within roughly 85 feet of the center line would solve a lot of his problems for future development. And they do state they're going to avoid any above ground infrastructure, which based on Burns and Mack's testimony from last week, I assume they're doing that.
Looking back on the scope of the assessment of oil and gas activities along the proposed route, would it be fair to conclude that the efforts by Evergy in advance of their proposing this line siting were perfunctory at best?
I don't know that for sure. I couldn't say that. I know that they don't reflect it in their study exactly. They do have protocols that state they're going to take that into consideration. And again, Burns and Mack witness stated that they had in fact done that as far as above ground infrastructure that's related to oil and gas.
Fair enough. However, the protocols that we've just made reference to and discussed require that such undertakings be conducted in advance of the line siting. Isn't that correct?
They do say it should be done during the routing study phase, which, as you pointed out, does happen before we undertake the proceeding we're in today. I guess that's all I can say to that matter.
All right. Let's turn to another part of your prepared testimony. On page 9, you commence a discussion of several bullet point conclusions. I want to draw our attention this morning, pardon me, to page 10, lines 12 through 14, which encompass this. It's the last of the bullet points. And let me read this into the record as I'm drawing it from Leo's prepared testimony, beginning on line 12, page 10. I quote, Evergy's protocols regarding oil and gas operations were consistent with the guidance found in the 24-102 docket, with the exception that the protocols did not include feedback from all of the oil and gas operators in selecting the preferred route. My first question is, again, I'm not trying to be repetitive, Leo, but to your best of your knowledge, how many operators did this solicitation of feedback affect?
That I know of today, we know of 2 that it's affected for sure. Val Energy and the the intervenor also.
2 out of
At least
all
2.
4. Yes, two out of all of the 4 counties affected by the route of the line. Is that correct?
That's what we know so far, yes, sir. That, as I know it. I don't recall
Yes.
oil and gas being directly addressed in the routing study.
Yes. That's all I can ask is that you testify to the best of your knowledge. I appreciate that. My next question is this. By not soliciting feedback from all affected oil and gas operators prior to selecting the route, has Evergy failed to comply with the important oil and gas protocols that we've alluded to?
I would say they have not complied with those protocols as we've alluded to. But I also would point out that the protocols, this is the first time they've been used. So it's a bit of a work in progress. And I don't believe that their failure to identify these oil and gas operators will substantially change the preferred route because of their ability to navigate through oil and gas leases.
Leo, if they don't understand, haven't assessed the scope of the problem, reach an informed conclusion about whether the route of the line is going to be impactful.
I agree with you. Yes, that's correct. They've not assessed that well.
Let me ask you this. In transmission line siting matters, if important and serious impacts of the siting are not adequately identified and assessed, they cannot be minimized. Isn't that correct?
I'm going to have to ask you to repeat that, Commissioner. You're breaking up on me here. I missed that.
In transmission line siting matters, if the important and serious impacts of the siting are not adequately identified and assessed, they cannot be minimized. Isn't that correct?
I would agree.
If the important impacts are not adequately assessed and minimized, there cannot be a factual basis for concluding that they are reasonable and in the public interest. Isn't that correct?
I believe you have to have a complete study to make a good, valid determination of the route.
That yes?
I believe that's yes.
Okay. Would you agree that the applicant for transmission line siting bears the burden of proof that the proposed line siting is reasonable?
Yes, it does.
Right. Leo, I appreciate your indulgence in my questions. I believe that concludes all questions I have for this witness.
All right, Commissioner Keither, any initial questions?
Commissioner King covered most of the ground that I was interested in, so I will hold off for now. Thank you.
All right, I think I wasn't gonna have a question for you, Leo. Oh, first of all, good morning, Leo. I wasn't going to have a question for you, but then as I think I heard you answer at the end of your questioning there with Commissioner Keen that you do not believe that Evergy complied with their oil and gas mitigation protocols. Is that correct?
I don't believe they received the feedback that should have been available from all the oil and gas operators along the preferred route. Now, I say that it wasn't mentioned in the study, as I recall. However, Burns and McDonnell did say on the stand that they had subcontractors that did review that and had identified all above ground oil and gas infrastructure that could be an obstacle to the course, which was pretty much the main tenet I saw in the protocols related to oil and gas.
I guess that's my question. That's definitely how I read those protocols, is that they would go drive around and try to find infrastructure related to oil and gas. And I understood that that's what they did. They didn't take another step of going and pulling land records or leases, which that would seem, I'm just opining here, but that seems beyond the scope of the protocol. So I'm trying to nail down exactly what it is that they failed to do that was in the protocols.
I would say they did not, as I can tell, get feedback from the oil and gas operators. They identified them through consultants. I don't know exactly what the consultants did, but my point is I didn't see any evidence that they had got feedback from oil and gas operators related to the preferred route. And clearly, I'll add, clearly on the conversation I had with Val Energy, he had no idea this line was going in there until the landowners had contacted him and told him about it.
So, so the missing step, you believe that there was infrastructure that they should have seen and followed up with the owners of that infrastructure? Is that where you're saying they missed the step?
If and I believe the protocols do require them to get feedback from oil and gas operators, I don't see them where they actually got that feedback, or they at least identified what they learned from that feedback.
Oh, okay. So, so you're just saying maybe they should have done something like put out a notice in an industry publication or taken some affirmative step to get feedback in compliance with the protocols. That's kind of what you're alluding to?
In my opinion, the identification of oil and gas operating leases is pretty easy to do, as Commissioner Keene alluded to. And you could easily contact them to understand, let them know about the route and understand what their concerns are, and actually to educate them on what they need to do or what you need to do to have a route in that area.
Okay. Yeah, I think I understand you now. Thank you, Mr. Hanos. I think that's all I had. I just needed clarification on that point. Okay, let's see. If there are no additional commissioner questions, we will move to the landowner interveners next. Mr. Zakura, do you have examination for this witness? You are on mute if you're speaking.
It's my same problem with the microphone when I was in person, right? Thank you, Chair French. Good morning, Mr. Hanos.
Morning.
Can you hear me?
I can.
Okay. Always a pleasure to see you, sir.
Thank you.
I want to go back in some limited questions I have. And this is the grain belt protocols that were adopted by the commission in the order which we took judicial notice of. So I would direct you to that page 3, which is attachment A. Okay. And I want to go over first with you at the top of the page, which is labeled 3. It says routing and siting. Do you see that, Mr. Hanos?
I'm trying to find what document you're talking about, Mr. Segura. You said it's 24/790 docket.
It is, Mr. Hanos, it is the document entitled Notice of Filing of Grain Belt Express LLC Oil and Gas Protocol.
Yes, I have it here now.
And on page 3 of that document, sir, do you see at the top where it says routing and siting?
Yes, I do.
And there's an A and a B, right?
Yes.
And the first one says, A, during the routing study phase of the project's development, Greenbelt Express will seek to identify existing oil and gas infrastructure on parcels within the study area. Do you see that?
Yes, I do.
And it doesn't say anything about above ground, does it? It just says oil and gas production infrastructure, correct?
That's correct.
And that could be underground pipe, it could be any number of things. It could be wells that aren't producing, it could be wells that are producing, it could be all of those things. Would you agree with that?
Infrastructure would include all those things.
Now, I think you indicated to Commissioner Keene that the information with regard to how many wells and have been drilled is available from KGS and others. And that's fairly accessible. Well, it's very accessible information. Would you agree with that?
Yes, I would.
I did some research on that, and in Cowley County since 1980, there were 8,855 wells drilled and 6,363 wells drilled in Chautauqua County since 1980. Have you looked at that? How many wells were drilled? We're not just talking about existing wells, but have you looked at that issue?
We did in a little different context. What we looked at just briefly was how many oil and gas wells or locations were in the Flint Hills moratorium area. And from what we can tell, there are 95,000 oil and gas wells, locations, or drill sites that are in the moratorium area that are related to Governor Sebelius's original attachment, or actually through the Brownback revision as well.
So it doesn't surprise you then, would I be correct, Mr. Hanos? It doesn't surprise you that I could, just on initial research, find 15,218 wells in Cowley and Chautauqua counties.
Not at all. There's a lot of energy infrastructure throughout this whole area, including pipelines that intersect the area we're talking about.
And you would agree with me that on the routing and siting, the number A that I just read to you, that the infrastructure in the study area was required to be identified.
It says they will seek to identify it. Yes, it doesn't say they will identify it, but I would take it to that they should at least make a good attempt.
And in item B, this, however, when developing a potential route network, it says Greenbelt will, to the extent feasible, avoid routing transmission line segments that include existing above ground. I emphasize above ground oil and gas infrastructure within the right of way. Do you see that, sir, also?
I do.
And that's a distinction between A and B, correct? Between oil and gas production infrastructure and above oil and gas infrastructure. Is that correct?
Yes, it is. It's also, B talks about within the right of way, assuming the preferred route, I guess, there, versus the other one looks at the whole region.
Mr. Hanos, thank you. I have nothing further.
All right, thank you, Mr. Zakura. We will now turn to Buck Oil.
Good morning, Mr. Hanes. How are you?
Very well, sir.
Mr. Hanes, you're testifying on behalf of commission staff, correct?
That's correct.
And a part of your testimony addresses the transmission siting protocols recognized by the commission, correct?
That's correct.
The commission issued an order in docket 24-790, approving transmission line siting protocols, correct?
I believe it was in 24-102 was where they approved the protocols. 790 was the Greenbelt Express line, which they adopted those protocols put together by Greenbelt as minimum protocols for oil and gas.
Okay, thank you for the clarification. And those protocols referred to in that order contemplate identifying oil and gas operators along a proposed transmission route, correct?
That's correct.
And they also contemplate coordination with those operators regarding potential impacts with oil and gas operations. Is that correct?
I believe they do, yes.
So in order 24102, it discussed how transmission routes should be evaluated and referenced the commission's adopted siting protocols, correct?
Yes.
And do you agree that the guidance recognizes that oil and gas wells and operations are considerations that should be weighed when evaluating transmission routes?
I don't remember if they included oil and gas in the weighing criteria, but they did put it as a standard, meaning a level where kind of above the criteria level, if you will, in the protocols or in the 24102 docket, where it really tries to address that in all cases you should consider these parameters to make sure that you understand how the line would affect oil and gas operations.
So the purpose of those protocols is to help identify potential impacts between transmission infrastructure and oil and gas operations, correct?
Yes, it is.
And in identifying these impacts can help inform whether a particular route is reasonable, correct?
Yes.
In your testimony, you stated that Evergy's protocols regarding oil and gas operations were generally consistent with the guidance in docket 24102.
I believe that's right.
But you also testified that there is one exception, correct?
One exception is where they didn't, and as I just was discussing with Commissioner French, where they didn't go out and get feedback from the oil and gas operators as part of the routing study.
And getting feedback and identifying these oil and gas operators along the route is important. Is that correct?
It's one facet of it. I don't know if it's a minor importance or major. I mean, they built a lot of transmission lines through a lot of oil fields without anything that couldn't get resolved. So I think it's a factor, and it was meant, as all the protocols are, as a way of engaging impact on the public, engaging the public to understand the best fit, best route to put through that area.
But to your knowledge, only one operator was contacted. Is that correct?
I don't know if any operators were contacted. I know that Val Energy was not, and based on the testimony of your client, I would say your client was not noticed either.
You also testified that there is evidence of considerable oil and gas activity along the entire proposed route, correct?
There's considerable oil and gas activity in the Flint Hills. Along the exact route, the only part that I saw that I'm aware of actually are the two fields that we're talking about, the one operated by your client and the one closer to Arc City that's operated by Val Energy.
Do you acknowledge there may be other active oil and gas leases impacted by the route that you're not aware of?
Right. Given, as I mentioned earlier, given the fact that so many oil and gas wells in the Flint Hills in general, it's very possible that other fields could be impacted.
So as you testify here today, you cannot identify all of the oil and gas operators whose leases may be affected by the proposed route, correct?
I did not.
Do what?
I did not identify any leases other than the two operators that I've mentioned.
Can you tell the commission how many oil and gas wells the preferred route crosses?
I cannot.
So the number of existing wells affected by the preferred route has not been identified, correct?
If they have, I did not see them in the routing study, and I did not see them in any other documents that I reviewed.
You set forth in your direct testimony that conflicts with wells can be addressed through micrositing.
I believe I did. I'm looking for it right now, but subject to check. Yeah, I would agree with that statement.
But micrositing occurs after the commission approves the route, correct?
That's correct. In other words, the route itself, the fact that putting a transmission line or navigating a transmission line through an active oil and gas lease is not an insurmountable obstacle to siting a line. It can be moved around and fitted through there.
Do you believe that micrositing is consistent with the commission's previous order?
Trying to think if an order has ever addressed micrositing specifically. It's definitely something that every line siting case that I've been involved with has always allowed in order to resolve any type of conflicts that were being observed in the route.
Didn't you testify that this is, I don't want to put words in your mouth, but you said this is the first time that you'll be following these protocols from 24-102?
Yes, the protocols were came after the line sighting between Wolf Creek and Blackberry. The commission decided that protocols was something needed to be done as far as investigating how we interacted with landowners. And 24-102 was a general investigation involving a lot of stakeholders. I was involved very beginning, and then I was out of it until now. So that whole process developed the protocols as far as the best way, or preferred way, I should say, that you can help stakeholders become more involved in this process to do line sighting. Mr. Owens, who's coming up in a little bit to testify, was part of that whole investigation as well.
So this siting has different protocols for oil and gas mitigation than these previous ones that you're alluding to. Is that correct?
This is the first siting docket that we have had the requirement that protocols be followed.
So jump back to micrositing. So the exact locations of transmission structures, they haven't been determined yet, correct?
They have not.
Do what?
They have not been determined, no.
So the precise impacts to oil and gas operators or existing well locations are not yet known, correct?
I don't know if they know the precise location. I would say they do not. I don't know that though.
The oil and gas industry protocols recognized by the commission are intended to assist in identifying impacts on oil and gas operators and existing wells before a route is selected. Is that correct?
That's correct.
So the preferred route in this case was selected before input was obtained from all affected oil and gas operators and before the number of impacted wells has been identified. Is that correct?
If you mean the preferred route as it is today, because micrositing is allowed and is something that we staff at least would certainly encourage, the final route is really not selected until the micrositing is complete. So, you know, this narrows it down, right? This route that we're looking at takes it down to pretty much the line that's involved. But all along here, and you're going to hear this, I think, later on today from another staff witness, Mr. Galino, we've worked to modify this in order to better fit the protocol criterion to mitigate impacts on other landowners, et cetera. In the case of oil and gas wells, we started that with our conversations with Val Energy, but we've not finished that as far as micrositing to avoid or navigate through existing oil fields.
Mr. Hannes, but aren't we here today to determine the necessity and reasonableness of this route?
We are.
And one of those protocols for oil and gas is to help the commission identify if this route is reasonable.
That's correct.
It's not would you agree that it's not to determine if unknown wells that have not been identified and structures can be microsited around?
I think it's a little of a chicken or an egg thing there. You're never going to know that until you're actually surveying where these poles are going to go and what's there. So you have to pick a route before you finish the micrositing.
Didn't you testify that the protocols are determine the impact on infrastructure in the region?
I believe that's correct.
So has that been done here?
As I recall, the routing study performed by Burns and McDonnell, I don't recall them discussing oil and gas infrastructure. And it may be in there, I don't recall it. I do recall their witness saying that they indeed did look at that. And that was what we testified to last week.
And their plan was to look at this after the commission determines the necessity and reasonableness of the line, correct?
Burns and McDonnell performed the routing, the regionals type of study, and then through their process of elimination, basically came up with the preferred route that minimized as many competing factors as they could, minimize the impact. And oil and gas is part of that impact that they should have looked at or did look at, according to their testimony last week. Although, I don't recall seeing it in the study.
Nothing further this witness.
All right. Thank you, Mr. Buck.
Thank you, Chairman.
We are back to commissioner questions. Are there any follow-on commissioner questions to those that the parties have asked? Commissioner Keen and Commissioner Keither, I can't see you, so just speak up quickly if you do have a
No,
question.
none for me.
Yes, I do.
Please proceed, Commissioner Keen.
Yes, thank you, Chair French. I have several follow-on questions, Lee. I'll try to be very brief. In the wake of the colloquy you had with the chair, some of the questions that were asked of you by Mr. Zakura, and a follow-up to some of the questions asked of you by Mr. Buck. Is there prima facie evidence? Let me start at a different place. If I understood your response to one of the questions directed to you by Mr. Buck, that the rallying study prepared by Barnes McDonnell, that rallying study doesn't really make reference to oil and gas activities or protocols to any extent. Is that correct?
That's what I recall, Commissioner. But again, their staff said they did look at that.
If we take that in tandem with other evidence that is spread before the record in this case, isn't there prima facie evidence of a lack of thoroughness by Evergy in assessing the impact on oil and gas activities along the entirety of the proposed route?
I'm going to ask you to define how you're defining prima facie evidence. What are you looking for there?
I think there's evidence from your testimony alone that there's a lack of thoroughness by Evergy. And without being thorough, how can they totally assess the impact? That's what I'm asking you.
Okay. I believe they did not be as thorough as they needed to be with oil and gas. I will say that there's been a lot of lines cited in Kansas over the years, way before my time getting involved 11 years ago, that go through active oil and gas production. And traditionally, or based on historical records, this has not been a problem with this type of granular look at oil and gas operations along the routing side. However, the protocols required that, and they didn't do that. Again, it's the first time the protocols have been used as well.
Well, that's a great lead into my next question. Does the fact that the siting that this is the first siting docket that utilizes the Commission's oil and gas protocols, does that excuse non-compliance with those protocols?
No, it doesn't.
With regard to the adequacy of soliciting or receiving feedback from existing oil and gas operators, I mean, doesn't that fact alone demonstrate an absence of thoroughness by Evergy?
In my opinion, yes.
Let me go back now to a couple of the questions that I asked you of you previously, and I want to have a follow-on to that I'd like to ask. I think you and I, in our previous colloquy in this morning, had pretty much agreed that if important and serious impacts of the siting are not adequately identified and assessed, they cannot be minimized. Isn't that correct?
If important, I'm sorry, could you repeat that? I missed that.
Yes, I will. In transmission line siting matters, if the important and serious impacts of the siting are not adequately identified and assessed, they cannot be minimized. Isn't that correct?
That's correct.
And if important impacts are not adequately assessed and minimized, there cannot be a factual basis for concluding that they are reasonable. Isn't that correct?
If they are important, that's correct.
Unless important line siting impacts such as oil and gas activities, unless these are identified, assessed, and minimized to the Commission's satisfaction in advance of line siting approval. Any Commission approval is premised on promise and hope and not on fact-based analysis. Isn't that correct?
I would say this, in the end, this is the commission's decision to decide if this is correct based on the evidence as has been presented. And I think that evidence has to be weighed along with the historical line sightings that we've done in the past and how they've addressed oil and gas, as well as the requirements for the protocols.
But I'll say again, and I'll ask again, unless important impacts are identified, assessed, and minimized to the Commission's satisfaction in advance of citing approval, that approval is going to be premised upon promise, speculation, and hope, and not on fact-based analysis. Isn't that correct?
I'm still not sure I understand your question. The commission will have to decide what factors are important. And once they make that decision as to what the importance is, at that time, it has to be based on fact-based analysis to make their decision. Hope I've answered your question.
But if we don't have the fact-based analysis preceding the decision on approval, that decision is based upon speculation, promise, and hope, is it not?
That's correct. You have to have facts to base your decision. In my opinion, I'm not an attorney, and I always try to get that in at least in one of these hearings. But in my opinion, you would have to have evidence in order to make a decision. Fact-based evidence, not emotion.
Exactly. Evidence. Thank you. Well, I completely agree with that. And I don't believe one has to be an attorney to be able to use inductive and deductive logic. Let me continue with another question then. Under such circumstances, and that would be in the case of the absence of any commission approval of in advance of satisfaction of important line siting assessments and minimization, isn't it the case that the utility, not the commission, becomes the arbiter of the adequacy of their own efforts to assess and minimize impacts without, before the fact, independent commission oversight, accountability, and approval?
I think that's correct. There's a lot in that sentence, and I'm not sure if I got it all. So, but I think I will agree with you.
I'll try to succinctly repeat it. I sense that you didn't understand it, but maybe I was too dodgy in presenting it. I'll try to improve that. I'm saying under such circumstances, isn't it true that it would be the utility, not the commission, that would become the arbiter of the adequacy of their own efforts to assess and minimize impacts before if we have an absence of before the fact independent commission oversight, accountability, and approval?
Yeah, I think that's right. I think what I'm hearing you say, Commissioner, is that without guidance from the commissioner or the directives from the commission, the utility becomes the person to really work out how to mitigate impacts. And that was the very reason for 24-102 docket, was because there was always we were always playing catch up, right? We would get these sightings with a lot of very sophisticated analyses in them that were based on estimates or subjective analysis. They would do a lot of calculations based on subjective analysis. And so the protocols come along trying to even that out a little bit and get a better look at how these factors or how these criteria are weighted. What's the proper criteria to look at? So that was the directive from the commission. That was, again, used for the very first time in this docket.
I appreciate the granularity of that answer. And I think in the process, you've also identified important public interest considerations behind the adoption of the protocol, have you not?
Yes, I think the 2410 docket, 102 docket was a important docket that sets the stage for this proceeding and for future line sightings.
One last question. Isn't it true that the absence of such before the fact of the approval, commission oversight, accountability, and indeed approval places the public interest at risk of being compromised, potentially in the name of either expediency or cost containment?
So can I restate your question if you could?
Please do.
What I understood you to say was that without the commission's approval, the decision to just react to a proposal from the company from the utility without fully investigating how it is going to impact the public becomes an exercise that is focused on expediency of the project and possibly minimizing the cost. Am I hearing that correctly? I'm sorry.
Correct. And in the process, put the public interest at risk. That's a good paraphrase.
That as I described it there in that hesitating way, I think that is correct. You need to understand the process. The commission needs to understand the process very thoroughly to protect the public interest.
And isn't that especially the case when we have serious public interest issues at stake that involve the welfare of a major component of the Kansas economy?
I'm sorry, could you repeat that one again? I've missed that.
Yeah, isn't that particularly, especially the case that we have when we have substantial public interest issues that are at stake that potentially involve the welfare of a major component of the Kansas economy?
Yes, and all of the factors there have to be balanced, because siting a line siting is going to affect the welfare of all the stakeholders that it crosses, whether they be economic interests or landowners, or just purely, well, they will be landowners, but homeowners, for example, or the viewscape, which we heard quite a bit about. All that is an impact. And the idea of a line siting doesn't pick a route that immunizes all of those parties from impact. It tries to mitigate or minimize the impact on as many of those as they can. Even if you look at the factors in the 102 docket, they all compete against each other. You have to pick the ones that you feel have the most importance to try to minimize the impact.
I appreciate the granularity of that answer once again. And we kind of go back in full circle, I think, to one of the earlier questions I asked, which is you have to adequately assess the impact before you can minimize, and you have to adequately assess and minimize before you can determine, as a matter of fact, that the outcome is reasonable. Isn't that correct?
I agree.
Leo, thank you for your testimony. And once again, I appreciate your indulgence of my questions. No further questions of this witness.
Commissioner Keither, any questions?
Yes, thank you. Good morning, Leo. How are you?
Doing well, thank you, Commissioner.
Um, I, I- I'm getting things rolling around in my head that, what is better than the other thing, and following the question from the commissioner. And it seems to me when our major concern we're talking about right now is the oil and gas industry and what the energy company does or doesn't know that they're dealing with, takes us to the issue of micrositing. And micrositing is after the fact. So I'm not quite sure, without having all the oil and gas issues identified ahead of time, how we can make the decision correctly when the landowners don't even know what they're going to get after the decision is made. Is that correct?
Yes, I understand your question, Commissioner. Uh, You're correct that micrositing typically happens after the fact. As you'll hear from our witness, Matthew Galino, here in a minute about micrositing, when we had information in front of us to use, we were able to microsite before the fact. In other words, we make several modifications to working with Evergy to move that line further away from homes in order
Right.
to get a better fit of what we saw as the uh, the biggest criteria to try to address, which was impact on homes. Um, Regarding the oil and gas side, I think we all, and I'm speaking for myself, I should say, and possibly Evergy, but I'll speak for myself. I, I felt that even though we were going through active oil and gas fields, given their operations and the ability, this right of way is only 175 feet wide, it's not 600 feet wide.
Mm-hmm.
This right of way could be sited between wells as we've successfully done throughout Kansas for all the previous line sightings we've done. They've crossed a lot of oil fields. Now, that being said, we had protocols out there that required them to get feedback from the oil and gas operators, required Evergy to get feedback. I don't think they got that, at least not to the level they could have got it, and it would have helped microsite before routing.
Mm-hmm.
So I guess what I'm saying is, yes, in this case, micrositing would be done after the preferred route was approved, as it's been done in all the previous transmission line sightings that we've done.
Mm-hmm.
Better process would have been to do it like we've done it for the homeowners, because in the past, the way we microsited around homes in the past was it was always done after the fact, and then it was done a little bit on the company's terms, on the utility's terms, as far as how that line would get microsited. So being involved earlier, having criteria that we can work with is certainly beneficial. But again, it has been done in the past through oil fields, and I think it can be done again.
Thank you, Leo. Thank you. That's all I have.
Welcome.
Leo, I think I do have a couple follow-ons. One, just on that last point, I guess I just want to restate what I think I heard, and then you can tell me if you agree, or you can clean it up. It sounds like the before or after the fact question of whether Evergy identifies the leases before or after the fact, at least in this case, as you look at the evidence, setting the protocols aside of the timing of when they should have looked at it, as I hear your testimony, it sounds like you don't think that's terribly material because of the size of the easement and the ability to microsite. Just like every line sighting we've done in the past, you think Evergy will be able to mitigate the impact on those leases as they actually do the final engineering and design and working with landowners. Is that essentially what I heard you say?
Yes, it is, and I would add to that if they can't, if there's a concern about impact on future drilling sites and that type of thing, that could come back to the KCC, and they may have to reroute that yet again. So even though the routing study would be approved with the expectation that they could microsite through these operations as they've always done in the past. But if they couldn't, they may have to move it, 1,000 feet or more than 1,000 feet. And we may be outside the realm of micrositing and be looking at making a modification to the route.
Thank you. That's helpful. And then the only other question, and I say only, do you have the Evergy oil and gas protocols in front of you? I know they're attached to the application. And I believe they're at page 6 of their landowner protocols.
Yes, I think I've got them. I have them pulled out of the document itself, so I'm hoping I have the latest version, but I think I have the right one.
Okay. Well, what I wanted to ask is, I feel like we've already initially, you testified that it was your opinion that Evergy did not comply with those protocols, and unfortunately, I wasn't able to pull them up in time to really parse them. But now that I did pull them up, so I was looking at the bottom of page 6. There's a heading titled Oil and Gas Mitigation During Transmission Line Routing and Siting Activities. And I'm going to paraphrase, but my reading of that is that's sort of while developing the route, Evergy will seek to identify existing oil and gas infrastructure. And my understanding is, there's sort of a disagreement about how well they did that, how much diligence they did. They said they drove around and identified infrastructure above ground. I think you've testified that they could have been more thorough if they had used perhaps a data source like KGS to identify leases in the area. Have I stated all of that correctly?
Yes, you have, and I think they could have been more thorough in maybe identifying the leaseholders, the operators, based on the data that's available to get their feedback.
But the one thing that then strikes me as interesting is so there's that section, which is the before section, and it says they'll seek to identify existing infrastructure. But then if you go down to the next section, and this is the oil and gas mitigation during transmission line engineering and design activities, and it in the first sentence it indicates this is what they're going to do after the final transmission line route is approved. And here in that next sentence is where it says Evergy will use good faith efforts to identify oil and gas facilities and operators that hold an interest on properties within the transmission line right of way. So my reading of it is, I mean, it certainly sounds like that was the intention, is that they would identify those operators and leaseholders after the final route had been identified. Is that different than your reading?
No, that's what I think Mr. Armfield testified to last week as well, that
Okay.
rather than try to do all the title searches, once they get the route established, then they would go to start doing title searches to understand who all the mineral interest owners are and discuss with them how to put the line through that property.
Okay. Well, maybe this may be parsing things to the point of nonsense. It sounds like, there may be some open question on whether there was compliance or non-compliance, but I think I understand your testimony that certainly in that early phase, there could have been more thoroughness. Is that's kind of what it boils down to. But at the end of the day, it doesn't sound like you think it's going to be terribly material as to whether the line is reasonable or not.
That's correct. I think
Okay.
but again, this was the first time they did this, so I think you have to give them a little slack of what we really want. We know it's worked in the past. That's where I would say it may not be quite as material as you said, as an impact that can't be worked through as we've done in the past.
Okay. I think I understand this as much as I'm going to within an hour this morning. But I do appreciate that, Mr. Hanos. Okay, any additional commissioner questions before we turn to redirect?
Mr. King has his hand.
Yes, if I
Right.
might, Chair
Yeah,
French.
yes, go ahead.
Leo, as a follow-on to the colloquy you just had with the chair, didn't you testify to the effect that one of the underlying reasons behind establishing these protocols was to bring some order to chaos, to try to bring some kind of formulaic process into a domain that didn't have a well-identified process previously?
I don't think I called it chaos, but in general, I would agree with your statement. Yes.
I'd accept any analogous phrase that you might have. It was less than organized, wasn't it?
It was less than organized. Yes, sir.
All right. So if we adopt these protocols and then we say, well, this is the first time out, so we're going to grant all kinds of slack. It doesn't matter what the detriment may be to those that are affected by granting that slack. But if we've adopted the protocol, should we not follow the protocols?
We should. And if the only thing missing from the protocols is that they didn't get feedback from the landowner or from the oil and gas operators, that's a pretty easy fix. Because I think, again, this can be cited through there. And speaking with the lease operators, excuse me, not the landowners as much, them too. But speaking with the lease operators, I think this could be easily remedied to make this docket more complete. But it is as I see it right now, has not been done, and it is part of the protocols as I read them.
How is it an easy fact? How's an easy fix before the fact at this point?
At this point, it becomes more difficult. That's true.
And isn't how easy the fix is really contingent upon an unknown here, because the assessment was so inadequate. We don't know the number of leases that are involved, the well counts that are involved. We don't have any idea the effect on oil and gas production wells, oil and gas injection wells, oil and gas disposal wells, or the presence of abandoned wells, which once the line is in place could be really problematic to try to remedy. Isn't that the case?
That is true. That is true.
And it seems like we're overgeneralizing fairly well here by saying, oh, well, we'll just fix this after the fact. I think that is a dodge on important responsibilities that we have in the public interest to make sure that, and in the interest and welfare of all these landowners that are affected by the route of this line, to know in advance what the impacts are. Then you can try to minimize them. Once you know, if you don't know them, you can't minimize them. If you don't assess the totality of it, you can't minimize it. And without minimizing it and assessing the totality of it, you don't have a fact-based basis for having a conclusion that the line is reasonable. Isn't that correct?
Yes, sir. You need to have a fact-based basis to make a decision.
Okay. Well, I'm kind of like the chair. I think we've beaten this into plowshares pretty much, but I think these are big distinctions with differences here that we're talking about, and the potential impact is substantial. Thank you, Leo, again.
Thank you.
All right. At this time, I think we will turn to staff for any redirect.
Commissioner French, if I may.
You may, Mr. Bailey.
Could Evergy ask a question?
Let's go
It's not
to.
in the order.
It is not in the order, although we have talked a lot about Evergy's compliance with the protocols, and so I do think it's probably within scope to allow you an opportunity to ask Mr. Hanos some questions. I'm just trying to figure out whether it would be most appropriate to do that before or after redirect. Actually, thinking on it now, why don't you go ahead and then we'll do redirect. So please proceed, Mr. Bailey.
Thank you. Hey, Leo, how are you?
Do well.
Let's see here. On the protocols, you made several recommendations for changes to our protocols, correct?
I did.
And none of those were concerning oil and gas.
They were not. At the time I wrote that, I did not, or I didn't really come to understand if the oil and gas guys or oil and gas operators had been contacted until after the public meetings.
Okay. And I think Commissioner French alluded to it, but in our protocols, we do, even the next paragraph down on those protocols, it says, I don't know if you remember this or not, but Evergy is going to work with leaseholders, operators to mitigate opportunities. And if the center line is going to impact those leaseholders, Evergy plans to move the route, correct?
That's correct.
And I think it was hit on several times, but talking about routing transmission lines in the past is the way we filed our application consistent with how most transmission dockets have gone in the past that you can remember?
Yes, I've been involved in these for 11 years. I think this is probably the fifth one that's been done. The last three have been greenfield, the only greenfield cases. They've all been since 2022. But of those dockets, this has been consistent with the way they've been filed. And even before that, I think the 24-102 study or staff's reports on those goes back and looks at a lot of different cases. And I don't think they ever called out a different way that oil and gas was handled in the past.
Okay, no further questions. Thank you.
Okay, thank you, Mr. Bailey. And now we will turn to staff for redirect, if you have any.
We do, Chair.
Okay.
Good morning, Mr. Haynes. First, I want to just point you back to the docket that was taken administrative notice of at the outset of this hearing today, filed in docket number 24 GBEE 790 STG. This is the notice of filing of Grainbelt Express LLC's oil and gas protocols. Do you have that in front of you?
Yes, I do.
And could you turn to attachment A? It's page 3 of attachment A.
Yes, I have it here.
Under the project development, engineering and design subheading. Just one more time, could you read into the record what it states at paragraph A in that subheading?
Paragraph A under project design and engineering design.
That's right.
Project development engineering design. After a route is approved, Grainbelt Express will use good faith efforts to identify oil and gas operators with production interests on parcels within the project's approved right of way.
Could you just clarify and testify from your understanding of what that means regarding the timing of contacting leaseholders?
What this says is that after they approve a route, they will identify oil and gas operators. And at that time, they will basically microsite across those properties as they need to work with have good faith efforts to solve the line siting.
Thank you. I don't have any further questions on that document, but I would like to turn back to the question of micrositing, which has obviously been a topic of discussion this morning. Your direct testimony on page 5, you discuss your perception of the benefits of micrositing. Could you again just clarify why you believe micrositing provides important flexibility for the line siting process?
You point me to where it is in my testimony here.
Page 5, paragraph 18, or sorry, line 18 and 19.
Yes, in this case, I was talking about the protocols more than just line siting, but it's the same idea. Line siting, or micrositing, micrositing gives the operator and the landowner a chance to negotiate and be flexible as to how that line can have the most minimum impact across a given property.
You believe that the commission could still find the proposed route to be reasonable, given this flexibility that micrositing provides.
I do. I think it's a little unfortunate that we don't have all of this micrositing more or less worked out beforehand. And I think we've done that for many of the homeowners. But in this case, it would have been a little better than a better way to do it. But I think having that flexibility is the right answer in the end. And as you point out, in the protocols that were approved by the commission in the Greenbelt Express docket, it was more or less stated that it was after the line was sited that they would do that work as far as oil and gas properties.
I believe I have one final question for you. If the commission were to approve the proposed route, would the commission be able to condition that approval on Evergy's compliance with making reporting about the impacts on oil and gas leases? And let me know if you want me to rephrase that question.
Well, I would say the commission can add any conditions they wish that are within the public interest. In my opinion, for these line siting dockets, and we've added conditions in the past in making the actual siting contingent upon certain tasks being accomplished.
I have no further questions.
Thank you.
All right, thank you, Ms. Hain and staff. If there are no further questions of this witness, Mr. Hanos, we thank you for your testimony today, and you may step down virtually.
Commissioner French,
Oh,
I did have a follow-on question.
okay.
I didn't realize
I'm sorry,
after
Leo, you're not released. You may not step down. Commissioner Keene has a follow-on question for you.
Yes, again, with your indulgence, Leo, I appreciate that. Evergy oil and gas protocol is their protocol. It's a derivation of the commission's protocol, is it not? It's not the absolute rote commission protocol.
That's right. I think, as I recall, the way that it was set up was that every line siting should have its own set of protocols built into it.
So my question is, isn't this aspect, that is the oil and gas protocol aspect of their protocols, to some extent inconsistent with the commission's oil and gas protocols?
It may be. I haven't compared them word for word. In general, I thought they flowed pretty well when I looked at them in the past.
What? I think it is. I think it is, because I think they have embellished theirs to point out the timing that they think is most timing issue that's most preferable to them. Let me go back to the last line of questioning that you received from Ms. Hain. Can you recall some of the events that were preludes to the development of the commission's oil and gas protocol?
I was not involved in the negotiations on the 24-102 docket. Mr. Owens was. He may be a better source for your question. I recall in general what led us to start the 24-102 docket. That was the Nextera case that for the line between Wolf Creek and Blackberry.
All right. So I'll ask you this question, answer it to the best of your ability. Isn't it true that concerns about the implementation of Evergy's grain belt oil and gas protocols was a major factor because of the confusion it caused and the consternation it caused that gave rise to the commission's incentive to develop its own oil and gas protocols?
I'm gonna defer that question to Mr. Owens. He was involved in both of those dockets. That was during my brief retirement, so I was not here for the case and the 24-102.
Okay, I will ask that of him. Thank you again, Leo. No further questions.
All right, since there were a couple more questions there, staff, any additional redirect needed?
No, thank you.
Okay, thank you. All right, then at this time, Mr. Hanos, you may step down. We do thank you for your testimony.
Thank you.
All right, we've been going a little over an hour and a half. I'm going to give everybody a 5-minute break, but before we break, just something for the parties to think about. As was discussed earlier, it sounds like our court reporter may have a hard stop at noon today. There's a chance we won't get through our final 2 witnesses by noon. So my inclination, if we have to do it, is to keep going without a court reporter, and we'll get that recording transcribed. I do understand the court reporter may be checking to see if we have another court reporter that could join us at noon, so that's also a possibility. But just want to make sure everybody's aware of my thoughts that even if we can't get a court reporter and we can't get done by noon, that I would propose to just go ahead and continue and then have the any afternoon proceedings recorded for future transcription. Nobody needs to weigh in on that now. I'm just going to ask you to think about what you'd like to do. And so at this time, we are going to take a 5-minute break. We are now off the record, and we will return at 10:41. So with that, we will see you all in 5 minutes. And if I can have IT just mute everyone's microphones.
Hi, this
now.
is the court reporter. I
Oh.
just got a note that there is somebody at noon.
Oh, wonderful.
Yeah,
Wonderful.
so that's great. I just got the note, so.
Do you need one of us to send a link to that person, or are you able to forward it?
I would think they would do it. I
Okay.
would think the company would do it, so.
Okay.
Yeah, I think everything should be secured and,
Okay.
so like maybe 5 minutes to 12, we could maybe, or I don't know if do you guys take lunches?
We do. We'll probably take a 30 or 45-minute lunch break today.
Okay.
And so, well, we'll just see where we're at as we approach noon, and I'll try
Okay.
to stop a little early so we can check in with you and make a
Yeah.
plan for how we do the handover.
Yeah. Yeah.
Wonderful. Thank you so much, Kristen.
Yep.
Okay, and everybody is muted, Chair.
Thank you, Michelle. All right, I have 10:41. Before we go back on the record, just checking to make sure we have counsel for all parties. I see Mr. Zakura, I see Mr. Buck.
Yep, I'm here.
Mr. Bailey, are you there? Ms. Hain, do I have you? I do see you. Okay. Mr. Bailey, I think you're the last one we are waiting on.
I'm sorry, I'm here. I
Okay.
was running upstairs with a cup of coffee.
Yeah, same
Heard
here.
you call my name.
Just so the parties are aware, I don't know if you caught the discussion between myself and the court reporter after we went to break. It sounds like we will have another court reporter available for this afternoon if we need to go into the afternoon hours. So probably if we have to do that before lunch, we will take a short break just to discuss how that handover is going to take place. But it's possible we won't need to. So let us go ahead and proceed, and we'll see how far we can get this morning and potentially wrap up. So with that, we are now back on the record in the evidentiary hearing of this proceeding, and staff, you may call your next witness.
Staff calls witness Matthew Galino to the stand.
All right, Mr. Galino, if you will just say something real quick so you pop up on our screens.
I'm on the same mic. Can you hear me?
We can hear you, and I'll have the court reporter swear you in.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good afternoon, or rather good morning, Mr. Galino.
Good morning.
Would you please state your full name for the record?
My name is Matthew Archigolina.
Who is your employer and what is your title?
I'm a utilities engineer with the Kansas Corporation Commission staff.
Are you the
Okay,
same?
I'm having trouble hearing him. He sounds more muffled.
Yeah, it's the same here. Would it be possible to get the microphone closer to the witness?
Is this better?
That is
Yes,
better for me.
yes.
To repeat, I'm a utilities engineer with the staff of the Kansas Corporation Commission.
Are you the same Mr. Galino who filed direct testimony in this docket on January 29th?
I am.
Do you have any corrections or changes to make to that pre-filed testimony?
I
at
do
this
not.
time? Mr. Galino's testimony has already been entered into the record, and so with that, I tender the witness for commissioner questions and cross-examination.
All right, thank you. Are there any initial commissioner questions for this witness before we turn to the interveners? Commissioner Keen, do you have any questions?
Yes, very briefly. Thank you, Chair French.
Please
Good
proceed.
morning, Matthew.
Good morning.
Hello? Matthew, can you hear me?
Yes, I can.
It shows here that I guess you're not on mute, although it shows that on the screen.
I'm using two different mics, if that makes sense.
Oh, that's good. Okay, very good. As I read through your testimony, you're focusing pretty much exclusively on modifications, 12 modifications in particular, that have been made to the preferred route of Evergy to date. Is that correct?
That's correct.
Absolutely no references or consideration whatsoever to anything pertaining to oil and gas activities whatsoever. Is that correct?
That's correct.
And with respect to the 12 modifications you are proposing to the route here, most of the modifications pertain to what? The avoidance of home sites?
Yes, that was the primary aim of these modifications.
Okay. I have no further questions.
Sorry, Commissioner Keen, you broke up a bit. I believe you said no further questions. Can you confirm?
I'm sure that broke up. Can you hear me better now?
You're still
You are
breaking up.
really, Yes.
It,
yes.
it says your network bandwidth is low, so you may want to go camera off.
I've taken the camera off. Does that help?
I
Can you
think
hear
it
me
does.
now?
Yes, we do hear you now.
Yeah.
Okay. I see Lee Smithy been acknowledging that that's the case. And so at least that's probably the most distant point from where I am. Very well. I forgot where we were. Oh, yes. That I did, in fact, say that was the end of my questions.
Okay, very good. Thank you very much. Okay, Commissioner Keither, do you have any initial questions of this witness?
Not at this time. I'm going to hold.
And I also do not have any questions of you, Mr. Galino, so we will turn to see if there is any examination from the interveners. Beginning first with the landowner group, Mr. Zakura, do you have any examination for this witness?
Thank you, Chair French. I do not.
Okay. Mr. Buck, do you have any examination for this witness? Mr. Buck, you are on mute if you're speaking to us. You
I
are
read his
still...
lips. He says, no, I do not.
Okay. Maybe our IT can get him off of mute. Are you able to?
I can only ask to unmute.
There we go. He's
Sorry,
on.
guys, I'm on. No, I do not. Sorry about that, Chairman French.
No worries. We've got you now. Okay. Then let's see. Well, I guess since there were no follow-on questions after the last round of commission questions, probably no other commissioner questions. Staff, any need for redirect?
We do not.
Okay. All right. Well, then at this time, Mr. Galino, we do thank you for your testimony, and you may step down virtually.
Thank you.
Staff, you may call your last witness.
Staff calls Paul Owings to the stand.
All right. And Mr. Owings, I'm going to have the court reporter swear you in if you're ready.
Yes, sir.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good morning, Mr. Owings.
Good morning.
Will you please state your full name for the record?
Paul Owings.
Who is your employer and what is your title?
I'm employed by the Kansas Corporation Commission. I'm the chief engineer in the Utilities Division.
Are you the same Mr. Owings who filed direct testimony on January 29th, testimony in response to public comments on February 23rd, and testimony in support of the settlement agreement between SPP staff and Evergy on March 6th in this docket?
I am.
Do you have any changes or corrections to make to any of that testimony at this time?
I do not.
Mr. Owings' testimony has already been entered into the record, and so with that, I tender for commissioner questions and cross-examination.
Okay, thank you. We will begin with any commissioner questions, and I will start with Commissioner Keene. If you have any questions of this witness?
I do, Chair French. Bear with me a second. Okay. Yes. Paul,
Yes, can you hear me?
can you hear me?
Yes, I can.
I can now. Can you hear me?
Yes,
Can you hear me? Am I cutting out?
I can hear you.
Okay. I do have several questions for you, Paul. Some of them are, quite frankly, I think pretty difficult questions. I want to say at the outset here that I certainly respect your skills as an engineer. And during the times that we've worked together, I found that you are thoughtful and objective, even when we may differ over conclusions and results.
Thank you.
So I appreciate your service. My first question is this. Aren't the benefits and burdens of this proposed line disproportionately shared among the stakeholders? And by that, I mean, most benefits, it strikes me, primarily crew to
You're
Missouri
gonna,
customers?
excuse me, you're gonna have to probably take your video down. Thank you.
It's down. Can you hear me better now? Can you hear me
Yes,
now?
thank you.
Okay. That gives everybody a break. So that's good too. You want me to start the question again? I'm asking the court reporter.
Yeah, that's fine. That would be fine.
Okay. As a preface, I ask if the benefits and burdens of the proposed line are they not disproportionately shared among the stakeholders? And I was trying to explain what I meant by that, and in the process, have a response from Mr. Owings.
Sure.
Is go ahead. Let me add a question to that, Paul, if you would. Isn't it true that most benefits primarily accrue to underserved Missouri customers, Evergy and Evergy customers, while Kansas landowners and surface users bear the burden of disruption or of their preferred land uses and surface control? That's the question.
Okay, I think I understand. Thank you. So in my analysis of benefit, I looked at all of those factors. And I guess to begin with, I saw those factors as additive. I didn't see them as items that should be proportioned out. So I believe the statute requires us to analyze benefits to Kansans, benefits to consumers outside of Kansas. So that would be Missouri, presumably in this instance, and economic benefits in Kansas. I can start with the benefits outside of the state, and I'm going to start by just saying, you know, I'm a civil engineer. SPP witness Rahim provided some excellent testimony about the modeling and the reliability benefits, but I'm going to give you my my civil engineer view of what he said. So what I heard him say is that there was load shed in Missouri. So, you know, that's an indication, you know, these model, I guess to preface this came from the, you know, winter reliability models developed by the SPP, and these specific projects came from Winter Storm Elliott. So that's what they looked at. There was load shed in Missouri and not in Kansas and Oklahoma. So based on that fact, I think you could, you know, conclude that Missouri has a greater reliability benefit than Kansas and Oklahoma. And I'm just speaking in terms of reliability here, but I don't think that the reliability benefit to Kansas and Oklahoma should be downplayed. Specifically, I feel like he said Kansas and Oklahoma were near misses, and I'm using my own words there. He, if I recall, basically said, had the conditions been different, had the weather been different, we could have faced similar load shed in Kansas and Oklahoma. So in terms of reliability, I understood it to be Kansas and Oklahoma were near misses. Missouri was a hit. You know, he, I believe, testified in his written testimony that there were voltage and thermal violations, which are NERC standards in Kansas. And this line will reduce those voltage violations in Kansas. I think he said overall there's a 93% reduction. You know, I think eliminating those violations on Kansas's transmission system is very important. And I think one thing that's not directly stated in written testimony, but you know, the import capacity for Kansans of this line is 1,792 megavolt amps. I think roughly that converts over to 1.7 gigawatts. So this line can move more power into the state than both the Viola and McNew plants combined, it has that capability. I think that is a definitive benefit to Kansas. I think that, Kansas can see economic benefits in terms of removal of those transmission constraints, opening our generators. We have an excellent natural resource in Kansas, the wind generation, to move power, which benefits Kansans. We have the congestion relief. In terms of who benefits the most and who bears that burden, which was the original question, I go back to the fact that I see those benefits as additive, and I didn't perform an analysis where I tried to determine the primary beneficiary. I saw all those facts in combination supported the necessity of those lines. We touched on how the ITP model forecasts $2 million per year in congestion relief in Southeast Kansas. The cost models show that this line pays for itself by 2034. We have the fuel clause benefits that Evergy Witness Ives discussed. So I guess to answer your question, I see it as a totality of all those factors. And, preventing load shed in Missouri is a benefit and supports the necessity. So that was how I analyzed the line, Commissioner.
Okay, thank you. I appreciate the granularity of your response, Paul. I'm going to do a little back, and I'm going to change subjects here, and we'll come back here to issues that bear on the route here shortly. But as a follow-on to the colloquy that I had with Commissioner Haynes, were you present at the time of my cross-examination of Leo?
I was.
At the very conclusion of that, I asked him a question that he would defer to you, and so I'm going to ask you this question. You were somewhat intimately involved in the development of the protocols as they pertain to oil and gas activities, were you not?
Yes.
And he was alluding to the fact that under the Evergy, too many vowels at work here, but the Evergy grain belt oil and gas protocols, it specifically provided for after the fact of approval compliance with those oil and gas protocols. Do you recall that part of our discussion?
Yes, after approval of a route, then Grainbelt said they would use good faith efforts to identify oil and gas operators and work with them to mitigate impacts.
Exactly. Well, if I can maybe help refresh your recollection, or you can just refresh mine. Isn't it true that several of the commission's concerns, particularly about the implementation of those Evergy oil and gas protocols, raised so many questions that it became a major factor that gave rise, in fact, to the consideration and development of the commission's own oil and gas protocols?
I think I missed the first part of the question, but I think I understand the question.
I can restate it. Succinctly stated was that the Evergy protocols were so poorly after the fact implemented that they gave rise to so many questions about, I guess, in effect, the good faith that was to follow because of the angst it caused amongst operators, oil and gas operators, that was one of the major considerations behind and impetus behind the development by the commission of its own oil and gas protocol.
Okay, I got you now. So this is my recollection. We did the Grain Belt Express AC collector line docket, and during the hearing, you and I had a discussion about protocols. I'm going to back up a little bit, actually. So during the course of the Grain Belt docket, staff became aware of the two other types of protocols, the land odor protocols and, you know, on the spot, it's slipping my name, the you know, mitigative protocols for landowners and property damage protocols. And we issued discovery to Grainbelt and got those. They had them for Missouri, I believe. Staff put those into the record, and then the commission, I think staff also recommended that Evergy issue those protocols for Kansas. So we put the Missouri protocols into the record and requested that Evergy issue those protocols for Kansas. And then I believe it was on the witness stand, similar to today, you and I had a discussion about oil and gas protocols, and I think, you know, through questioning, I said it would be beneficial to the state of Kansas if Evergy produced oil and gas protocols. Now, whilst we were doing this, we were also doing the general investigation in parallel. And then I think that the hearing was in August of 2024. I'm going off of memory, so subject to check. And shortly thereafter, the commission issued an order requiring Evergy to develop oil and gas protocols. And I believe that Evergy even asked for an extension in their development because we were negotiating the nature of what oil and gas protocols should look like, and we had an upcoming workshop. Then we completed the workshop with, you know, a number of transmission operators, Tioga, EKCE, and several other intervenors, including Kansas Livestock Association and Kansas Farm Bureau. And we made some conclusions based on those meetings on the nature of those protocols. Evergy then filed the oil and gas protocols I wouldn't say mid docket, but towards the end of the general investigation docket. And if I recollect correctly, the commission accepted those protocols. And then in my third R&R on the general investigation, you know, primarily at the request of the utilities, they said, what should these protocols look like, staff? I cited those protocols because they were recently adopted. And I think there's that sentence within the order that is quoted about how they could be considered the minimum. That was a quote from the report and recommendation staff wrote. And then I believe the commission in its order said they would be considered a minimum. That's my recollection of the history of those things.
I'm sorry, Paul, you cut out a little bit on the very last sentence.
That's my recollection of the history.
The one before that is about the whether or not what was the impetus of it? What were you alluding to there toward the end of your thought?
So towards the end of my thought, staff wrote our R&R, and the Evergy protocols, the grain belt protocols had recently been approved by the commission. So within the R&R, I made a statement that basically said Evergy's protocols could be viewed as a minimum because the utilities were questioning what these should even look like since they hadn't developed them previously. And the R&R that myself and other staff wrote was quoted in the commission order, that statement that they could be viewed as a minimum. And then within the findings of the commission order, I think the commission said they should be viewed as a minimum. So the commission brought that set of Evergy grain belt protocols in and said they should be. The only thing I would add too is that the general investigation definitely made clear that, you know, the protocols were a specific utility's internal policies in working with oil and gas, and we weren't going to specifically prescribe how they did that. Rather, they needed to develop them, and we stated that this it should be viewed as a minimum.
All right, well, the oil and gas protocols that Evergy is utilizing in this particular docket are of Evergy's derivation, are they not? These are not protocols that per se have been approved by the commission. Is that correct?
That is correct, yes.
Let's switch back to the line itself and the route now. Thank you. I wanted to pick up on that as a follow-on to Leo's testimony and kind of clean it up before we focus on other matters at hand. First of all, I want to have us turn to your direct testimony on page 5, lines 4 through 7. And with your indulgence and that of the court of reporters, I will, for the benefit of all of those in attendance here, read into this record your direct testimony. Again, we're at page 5, pardon me, lines 5 and through 7. The question you're answering that preceded this was, are the modifications, that is to the preferred route, a net benefit? Here's your answer. It said yes, but it goes on. I'm quoting now. If the Buffalo Flats line is constructed, it will affect property owners for generations, if not into perpetuity. Staff contends that Evergy should make every reasonable effort to mitigate impacts on affected property owners. Period. Have I correctly reflected your testimony on direct, on that page, Paul?
Yes, sir.
In your opinion, in this case, has Evergy made, in your words, every reasonable effort to mitigate impacts?
Broad statement, and it's subjective because it's reasonable. I think all things considered, though, Evergy has proposed a reasonable location for this line and followed. And I see reasonable as standard of care, as a utility operating similar to what other utilities would do in a similar space. I think they have definitely done their due diligence to mitigate negative impacts and reasonably consider routes, and have completed a very comprehensive study that's similar to numerous other dockets that have occurred the last 25 years. So yes, I feel like they've done that, but I would qualify it to say that it doesn't stop here. It needs to continue through completion of the project. But for the specific, I guess, phase is what I'm going to call it, of the project that we're in, preliminary route siting, I feel like they've done that.
All right. In this docket, I guess my question is a leading one. Why isn't a concern for the effects this line siting has in perpetuity on Kansas landowners and surface users of equal or greater concern than Evergy's satisfaction of a near-term goal or arbitrary deadline?
I didn't understand the last part of that. I'm sorry.
What is the last part you didn't understand?
Evergy's satisfaction of a near-term goal, or, and then you go.
Arbitrary deadline, question mark.
So I think that this relates to the nature of SPP's conclusion that this is a short-term reliability project. You know, the SPP, and my familiarity is limited, but I understand they go through very rigorous stakeholder processes to make these determinations. And they viewed this as a significant threat to the regional grid, such that it should be a short-term reliability project. So that triggered this schedule that Evergy is on, a somewhat accelerated schedule to eliminate these concerns. You know, I think they stated that they viewed these violations of reliability standards multiple times in these areas. They saw load shed. Kansas and Oklahoma was a near miss. So their board made the determination that this needed to be completed quickly. I think that led to Evergy being issued the notice to construct. However, I don't know that this has unduly impacted property owners as a result of that. I think Evergy's study and analysis procured by Burns and McDonnell, who's done numerous other analyses in the state, and who in fact did grain belts analysis and was referenced, was done in a way that affects property owners more than previous studies have done or previous line sightings have done.
All right. Let's turn to page 10 of your direct testimony, lines 18 through 21, on over to page 11, line 1. I'm quoting from the direct testimony at this point, beginning on line 18. Question: how did the state of Kansas electrical system perform in SPP's winter weather models? Question mark. Your answer is, beginning on line 20, singular possessive, Kansas's electric system demonstrated voltage violation and overloads due to high load, limited generation availability, and constrained transfers. The inadequacies were, on over to the top of page 11, concentrated in southeast Kansas. I think you partially answered this, Paul, but I prefer doubling back, if you can, briefly. How is this remedied? How is this concern about southeast Kansas remedied by this proposed line? Question mark.
Sure. And again, I like to caveat that I'm a civil engineer, not an electrical engineer, and I do not perform power flow models, but I'll give you my best understanding of how this remedies the issue. So the way I understand it is too much power was flowing from west to east over existing transmission lines within Kansas. I think there was a west to east transfer problem within the SPP region, and the transmission lines had physical capacity issues, and a thermal overload. The line is getting too hot. It's sagging. It's becoming overload. A voltage violation. I think in this instance, the voltage decreases because you're trying to move too much power. What this solution does, and what SPP has concluded under their FERC tariff as the solution, for a reliable transmission system is it gives those electrons a pathway, and a pathway with significant more capacity to flow to the areas of SPP's region that need that power. So it assists to transfer it. Not as much power will be flowing on Kansas's existing transmission system, and that will basically provide relief to our transmission system. And that is my understanding of how this project resolves those issues.
Okay. Let's return to several issues that pertain to routing. And in particular, I'm going to try to take up the first routing issue I have is about a choice between routing the east-west segment of the line through Kansas versus Oklahoma. To begin that discussion, let's turn to page 23 of your direct testimony. I'm focusing here on lines 10 through 18.
Okay, I'm there.
The question begins with, and I'll again read it for the record. The question begins on line 10 as follows. Can you describe how the start and end points of the Buffalo Flats line were selected? Your answer now begins on line 11. Southwest Power Pool, paren, SPP, end paren, identified the Buffalo Flats substation as the Evergy origination point. The Evergy project team worked with American Electric Power, paren, AEP, to determine the optimal location of the interconnection point at the Kansas-Oklahoma border, period. According to Evergy, the endpoint was determined to be, quotation marks, geographically best, end quotation marks, for both AEP and Evergy, period. Additionally, Evergy and AEP considered the Osage Nation Reservation in Osage County, Oklahoma, when selecting the end point. With respect to that, and that's the end of the quotation. Paul, with respect to that last sentence, when you say that Evergy and AEP considered the Osage Nation Reservation in Osage County, Oklahoma, as a possible ending point, what does that mean, considered? How is this considered? What do you mean by that?
So that was in reference and probably almost a quotation of what Evergy provided in response to staff discovery request 4. They made that statement that it was geographically best, and they considered the Osage Nation Reservation. I mean, I think in the next paragraph, I went on to conclude that the Osage Nation Reservation was a primary factor based on the fact that they chose the first county road east of the Osage Nation Reservation.
I'm looking, I don't see that, but I would accept that at face value. What I want to do now too, let's turn to, is that the totality of your answer?
Yes, if you'd like me to discuss what my conclusions about the start and end point, I can as well.
We may get to that. Let's go through that somewhat methodically if we can. Let's turn now to page 25. And I'm looking at, in particular, lines 5 to 9. And we'll pick up some other parts of this page in a moment. Again, it's page 25, lines 5 through 9. And the question begins on line 5, and it is, Alternatively, could the electric transmission line be located in the Osage Nation reservation? Question mark. The answer beginning on line 7, yes. However, the Osage Nation is a sovereign native tribe. While siting the electric transmission line on Osage Nation reservation may be possible, the process would have been more difficult and time consuming. Period. That's the end of my quotation. Did I quote that correctly from your direct testimony?
Yes, sir.
Why would that route be more difficult and time consuming? I guess we're comparing it to what eventually became the preferred route in Kansas.
Sure. So and I guess my knowledge about permitting electric transmission lines in sovereign Native American lands is somewhat limited, but I am aware that you leave state jurisdiction when this occurs, and that they have specific treaties with the federal government that dictate how matters of this nature are done. And I've done other types of infrastructure projects in tribal lands, and it's typically considerably more difficult. And I think referring back to testimony by Evergy witness Lovelace, he cited permitting issues that make it significantly take significantly longer to acquire, and then I would presume that they would have specific requirements in terms of construction and restoration that would be more cumbersome. That's my general understanding of those processes.
The entirety of Osage County, Oklahoma is within the domain of the Southwest Power Pool, is it not?
I believe Osage Nation is in the Southwest Power Pool.
Does the Southwest Power Pool issue notices to construct within the domain of the Osage Nation?
I don't think they select an area. I think they give a start and a stop point. And I suppose if a substation was in the Osage Nation and they selected it as a takeoff point, they would be issuing a notice to construct that had to cross the Osage Nation. But I don't think they look at the routing.
Well, exactly. And that's just exactly the case in the docket before us, isn't it? They selected the beginning point and ending point. They provided notices to construct to Evergy and AEP, and decided that they would allow them to decide between themselves what the specific route was going to be. Isn't that correct?
Yes, I think that's how they do all of their transmission projects. That's my understanding.
Two major questions about going through Osage County, Oklahoma for you. The first is, how much would such a route there add to the cost of the project, approximately?
Not quantified. I don't know.
How much time would a route through the Osage add to the construction schedule?
I believe Evergy witness Lovelace said years. A year or years, I can't remember. In terms of the federal permitting.
Okay. Let's say it added a year. Why is that debilitating in terms of disqualifying a route through the Osage Nation? Why is that debilitating?
I wouldn't say it's debilitating. My analysis evaluated the start and end point selection, and I concluded that it was reasonable for Evergy to avoid the Osage Nation considering the schedule requirements. I guess I don't think it's debilitating, but Evergy acting as a utility and behaving similar to other utilities made reasonable decision making to develop those points.
Take a look over and on the subject, which is related to this. Let's take a look at page 24, lines 12 through 16. The question begins on line 12, and it is as follows. In your opinion, what is the primary factor that impacted the endpoint location? Your answer begins on line 13 and stretches through 16, and it reads as follows. It appears that the primary consideration relates to the Osage Nation reservation, period. The endpoint is located on the First County Road east of the reservation, period. Based upon the preferred routes location and discovery responses from Evergy, the endpoint was selected to avoid the Osage Nation reservation, period. And if I correctly stated your comment?
Yes, sir.
So basically, the decisions between the beginning and the ending point as to the direction of the route were fully within the domain and selection processes of Evergy and AEP. Is that correct?
Yes, sir.
Did the KCC staff participate in any way in those decisions?
No.
Let's go back to page 25. In particular, lines 14 through 20.
Commissioner Keen, could you repeat that citation? That was garbled for me when you gave the citation.
Yes, certainly. It's page 25, lines 14 to 20. Could you hear me then?
Yes, I heard you then. Thank you.
Okay, yeah. Please do interrupt, Chair French, if it becomes problematic that I'm cutting in and out. I'd appreciate knowing that. Thank you. Okay, Paul. We're on page 25, lines 14 through 20, and I'll read it again in for the record, beginning on line 14. Constructing the line within the Osage Nation Reservation provides no apparent benefit in terms of cost schedule, comma, and amount of acres impacted. I'm going to continue to quote. Constructing the line on the Osage Nation Reservation benefits the specific Kansans impacted by the preferred route. However, constructing the line on the Osage Nation Reservation would most likely increase the cost of the project and extend the schedule, thereby harming Kansans not directly impacted by the route, period. Did I correctly cite from your direct testimony?
Yes, sir.
I have several questions that these last cited comments evoke. You say constructing the line within the Osage Nation Reservation provides no apparent benefit in terms of cost. What does that mean? And cost to whom?
The cost to all the ratepayers throughout the SPP as it's allocated. So I didn't see an apparent benefit in cost I didn't see it as a method to decrease the cost of the project.
Well, it's a little ambiguous the way the sentence is phrased, because you don't seem to imply that there's any negative to it either.
I do state there's a negative to the specific Kansans, not in that sentence necessarily, but in that concluding paragraph, who are specifically impacted by this line. I tried to remove myself from the emotion of the specific individuals impacted and think about Kansas as a whole, as the public as a whole, and the goals that this project was achieved.
I appreciate. Pardon me for talking over you.
When I made that conclusion, that was my thought process.
And I appreciate your sharing those intentions with us. In a previous question, I asked you how much cost would be added to the project if we went through the Osage. And if I recall, your answer was that you didn't answer. You deferred from answering that. Isn't that correct?
Yes, that's correct.
But now you're addressing cost in terms of having no apparent benefit or detriment, whatever. It's kind of incongruous to me.
I understand what you're saying, and allow me to please clarify. I haven't quantified the cost, and when I said, excuse me, in my direct, that there's no apparent benefit in terms of cost, I did not see this as a route that would decrease the cost of the project. And I think it was in part in my judgment, conversations with Evergy, conversations internally. So I didn't see it as a benefit in terms of cost.
Okay. Appreciate the clarification. Let's continue. Your next sentence is constructing the line on the Osage Nation Reservation benefits the specifics impacted by the preferred route. How is that so, and what is it you mean by that?
I meant that the preferred route impacts, I think, numerous Kansans from west to east, and moving it to the Osage Nation would benefit those specific people that it impacted.
What do you mean by specific Kansans impacted? I'm confused.
The people with the transmission line on their property or near their property.
Okay, so you're saying if it was constructed in Oklahoma, it would benefit the Kansans impacted directly by the route, by the preferred route, since the disruptions and the inconveniences would not be there. Is that correct?
That's correct.
All right. You go on to say, however, constructing the line on the Osage Nation Reservation would, your phrase, most likely increase the cost of the project. Let's stop there for a moment. What does most likely increase mean? I mean, that's kind of conjectural to me. Is that kind of a hunch that's based on unscored probability? I don't understand what that means.
What I meant is I haven't done an analysis of that specific cost estimate. However, I reviewed the documentation provided by Evergy and AEP, and the entire reason they avoided the Osage Nation Reservation was schedule and potential cost impacts. So perhaps I should have used apparently within the sentence as well, based on my reading of their response to discovery.
Okay, thank you for that. The sentence goes on to say that, in essence, constructing the line on the Osage Nation Reservation would also extend the schedule. I presume you mean the schedule for construction?
The entire project schedule, yes.
Okay. Thereby harming Kansans not directly impacted by the route. What is the harm you're addressing there, and how does that occur?
That gets back to necessity, and a hypothetical would be that if it extends the schedule 1 year and we have a winter weather event similar to Elliott, but without, some of the specific wind, I think there was extra wind generation. We had less wind generation on the system. We could have load shed in Kansas by delaying the project. And as we're all aware, if there's load shed, there can be billions of dollars worth of damage and loss of life and all sorts of other impacts. So extending the schedule could harm Kansans through routing it in this location.
Well, let's talk about that just a bit. That could happen from any winter weather event in any year, could it not?
Yes, sir.
Do you recall the timeline of events that I went through with Mr. Lovelace?
The schedule for this project, not.
No, it was the totality of the timeline from the winter weather events that gave rise to the concern through the construction of this proposed line. Do you remember that timeline?
Yes, I'm aware that Winter Storm Elliott occurred in 2022, and the, I think, scheduled completion year is 2029.
Let me briefly review that timeline for the benefit of everyone. Winter Storm Uri occurred in February of 2021, correct?
Yes.
Winter Storm Elliott occurred in December of 2022. Is that correct?
My understanding and recollection.
The Southwest Power Pool's integrated transmission planning recognize and seek to address the concerns raised by both of these winter storms in December of 2024.
Yes.
Evergy and American Electric Power received their notices to construct the Buffalo Flats line in September of 2025. When they received those notices to construct, it was 4 years after Uri, 3 years after Elliott. Isn't that correct?
That's what I recollect, subject to check.
The SEC order in this line sighting docket is due on May 13th, 2026. Construction of the line to commence, if the line is approved, approximately September of 2026. Isn't that correct?
That's what I recollect.
And the estimated line completion date is December of 2029. Isn't that correct?
That is what I recollect.
That being a timeline that we can generally agree on as being factually correct, that means that the estimated completion date is 8 years after the event of Winter Storm Uri and 7 years after the Winter Storm Elliott. Isn't that correct?
Yes.
So if we added another year to that timeline for consideration of running this line through an alternate route that might include Oklahoma and might include Osage County, the real trade-off is between that additional year, is it not, and the welfare of all of those affected directly by the preferred route of the line if it is approved. Isn't that correct?
Yes, I think that there could be routing it in a different location could add years to the process.
What do you mean by years?
One, I'm going back to the testimony of Lovelace where he said the additional permitting could add years to the process.
I remember a year. I don't remember the years. You remember it as being plural?
I think he said a year or more. I can't remember.
Okay, that's fair. That's fine. That's fine. I don't want to parse that with you. I accept that.
Check. Yeah, subject to check, right?
Oh, sure. I accept that. So evidently we have the fact that a route through the Osage was considered, it was available, and very possible to construct. But it appears that it was not chosen because of most likely cost increases and an extension of the construction time schedule, with the risk of harming Kansans not directly impacted by the route. Is that correct?
Yes, sir.
Well, all Kansans, because of the absence of a route between the date of Winter Storms Uri and Elliott through the estimated completion date in 2029, have been at risk every winter without the existence of a line, correct?
Yes.
So correct me if I'm wrong, but it seems like the decision was made that the harm to Kansas landowners affected by the Evergy preferred route is less consequential than the harm to Kansas landowners not directly impacted by the route. Is that correct?
Could you please restate that?
Yes. It appears that the decision was made that the harm to Kansas landowners directly affected by the Evergy preferred route, the harm to them is less consequential than the harm to Kansas landowners not directly impacted by the route. Isn't that correct?
I think I would qualify that it's not a direct comparison of the harm. It's analysis of Evergy's decision making relative to the reasonableness of selecting it. And while it may seem somewhat de minimis to add a year, that was decided in the SPP process, and Evergy was instructed to construct it in a certain time frame. So by acting to make that schedule, I think it was a reasonable recourse. I don't think that the weight of the impacts to Kansans that are directly affected and the potential for load shed were considered when making this decision. I think it relates to the notice to construct that Evergy was issued, and as a public utility and the incumbent utility, meeting that deadline that was required by doing this was a reasonable decision.
But the effect of choosing a route through Kansas in lieu of a route through Oklahoma actually did make the harm to Kansas landowners directly affected by the preferred route less consequential than the harm to all the Kansas landowners, did it not?
I think impacting more landowners in Kansas is a net increase in impact. Yes.
But the nature of that harm is speculative and conjectural, is it not?
The nature of the harm to property owners, I think, is definitive. It encumbers their property, and they have this infrastructure on their property for the foreseeable future.
Isn't there something else implicit in the choices that were made here? And that is that the extension of the construction schedule, hypothetically, by going through the Osage, was more detrimental than the long-term effects of the line on the land and the lives of Kansas landowners directly affected by the preferred route?
I think that Evergy and, you know, the extension of the schedule was not in Evergy's control. That they were issued the notice to construct and sought to fulfill their obligation. I don't think the SPP contemplated any of this. I think they had their own internal processes to determine this was a short-term reliability project, which set the schedule and later triggered these events.
Are you suggesting that an alternative route through Oklahoma and a division of responsibilities, perhaps different than what exists today between Evergy and American Electric Power, AEP, could not have met the construction deadline set forth in the notices to construct?
It was my understanding, based on Evergy's response to discovery, that that was part of the reason they considered this. And based on witness Lovelace's testimony, that there was concerns with schedule.
If the east-west portion of the route were changed from Kansas to Oklahoma, would the roles and responsibilities of Evergy and AEP also change?
I don't know that the roles and responsibilities would necessarily change. There would just be less line in Kansas and more line in Oklahoma, and AEP would probably have to permit a portion in Oklahoma and a portion through the Osage Nation's processes.
Isn't it true that there's one distinction with a difference between Kansas and Oklahoma in this particular set of facts? And that is that in Kansas, the foothills runs from the southern boundary of Kansas with Oklahoma virtually to the northern boundary of Kansas with Nebraska, the entire basically width of the state. Whereas within Oklahoma, it appears that the foothills are ballpark approximately 60 miles south of Ponca City, a far cry from a border-to-border situation we have in Kansas. Isn't that correct?
Yes.
I'm going to ask you another overview question, and I'll admit it's a leading question, but I'm trying to ferret out some of the details, some of the granular aspects of where it is we're today and how we got here. Notwithstanding the availability and convenience to Kansas landowners, but directly affected by the proposed route, of having the east-west segment of this line go through Oklahoma, Evergy and American Electric Power implemented a major trade-off and placed the interests of affected Kansas landowners and surface users secondary to the interests of Oklahoma landowners, Evergy's preferred construction timeline, and other Evergy interests. Is that correct or not correct?
I'm having trouble wrapping my arms around the full question, but I guess based on my recollection of the review of the discovery, the decision was made to do this based on mutual cooperation and the best solution that these two utilities saw for the project as a whole. I don't recall reading anything where they tried to consider who should be impacted more, Oklahoma or Kansas? And in my review of Evergy's decision-making, I thought they were reasonable. And if I was a utility trying to construct a transmission line on a tight schedule, I would prudently consider delays that could happen due to more complicated permitting requirements. I don't know that the impacts to Kansans and Oklahomans was necessarily a part of that decision in terms of the property owner impacts.
In terms of the decision the commission is faced with and whether or not to approve this line siding docket, are those trade-offs of concern to the commission? That is the route of the line and the impact upon Kansas landowners and surface users?
I think that impacts to Kansans are important to the commission, but I do think that, you know, we're selecting a route that was reasonably located within the state. And I've concluded that Evergy's decision-making was reasonable. So while the factors are important, my final conclusion is that it was reasonable to consider the schedule that SPP put in place, and it was reasonable to route it the way Evergy did.
Were alternative routes through Oklahoma ever mapped or scored by Evergy and AEP?
Evergy and AEP agreed on an endpoint. They didn't route and score things together. I don't think Evergy looks at any routing within Oklahoma. I presume AEP is completing their own routing analysis.
And they didn't collaborate at all in that effort?
I guess I don't know.
That's fair.
Beyond the endpoint, it was my understanding that they only collaborated at the point of interconnection, the handshake, not beyond that. But I don't have definitive evidence to that.
If they didn't undertake any effort to assess the relative impact on stakeholders of a route through Oklahoma versus one through Kansas, how could they possibly broach the subject of trying to minimize the impact of the line on the affected stakeholders?
I would say that this idea brings into question the way that our country cites transmission lines, and the fact that transmission line siting is primarily a state function and not a federal function, whereas a routing study is not completed state after state after state. They're bounded by state boundaries and require this communication, and one state doesn't contemplate the impacts to another state and vice versa. I would think that routing it through multiple territories would be more akin to a federal process, like the NETCs and different things, to think about the grid as a total. SPP acts somewhat in that function where they're thinking about the region, and they say point A, point B, point C, point D, but then they let each utility in that state connect those dots. So I don't think there's a mechanism or a process where the totality of multiple state impacts are considered.
Okay, I'm gonna cut in for just a second. This is Chair French. Just ask the court reporter a couple questions about her availability. If that's okay, Commissioner Keen, I apologize.
Yes, please.
We're gonna go off the record at this time. Ms. Liska, I understand you needed to stop at noon. Is it correct that you have a complete hard stop right at noon?
Yes, and there is going to be another reporter, Leanne Barnes, and she's going to start right at noon. And we probably don't even need to take a break. We'll just split. I mean, I'll just hang up.
Well, I was thinking about giving everyone a very brief break,
Yeah.
or maybe even taking a lunch break right now,
Okay.
because I'm guessing Commissioner Keen's got a few more questions. Is there any party that would object to just taking a 30-minute break right now? And Commissioner Keen, I really have to apologize if I'm breaking up your questioning, but would you object to just taking a 30-minute break now to allow the handover of court reporters and also allowing everybody to eat a quick bite of lunch?
Before we take that break, if I can kind of, for purposes of continuity, if I can, let me kind of finish this line of questioning and then we'll break, if you could indulge me for that.
Ms. Liska, what is the name of our next court reporter? And do you know if she's on yet? You're muted if you're trying to speak to us.
Sorry. Yeah, she should be joining here in a minute. Could she join right now? I'm going to see if she can hop on right now, and then you guys can continue and.
I know you said it could be kind of continuous, but I wanted to be fair and make sure that she was ready to go before we.
Yeah. And then also, while we're off the record, the stuff that you're quoting, do you have, could I have access to that? You know, like the depositions, like of Loveless, is there who I could reach out for that?
Yes, if you reach out to our general counsel, Mr. Tristan Kimbrell or Mr. Brian Fedotin, I suppose you've probably emailed with one or both of them.
Yeah,
if you reach out to
emailed
them,
me some documents. Yeah.
Yes, they can find anything that's referenced. If you ask for it, they can find it for you.
That is great. Okay, I'm just waiting for her.
Let's get her on before we go back on the record.
I think that would be great.
And it's possible we could, I don't want to jinx it. It's possible we could finish up before we have to take a lunch break. If Commissioner Keen wants to continue, we may be able to do that.
Yeah, I don't mind breaking up my cross-examination of Mr. Owings. I just would like to continue or to finalize just the questions I was asking him about the specific issue when we broke.
Okay.
Looks like we have Leanne Bates joining. Is that the other court reporter?
I didn't understand that.
It looks like we have Leanne Bates joining. Was that the other court reporter?
Yes, it is.
Okay. So she should be joined now.
Okay, great.
All right, Miss Bates, if you hear us, can you indicate if you are ready to begin?
I am set up and ready to begin, although I'm not I don't know what witness name you're on or
So we are off the record right now, just so you know, and we are in the middle of the examination of Paul Owings, a witness for KCC staff. So he's there, I believe he's their last witness.
And would that be Paul Owings?
Yes.
And then the other court reporter, I'll send you everything.
Okay.
I'll send you everything by email.
So, like all the other people who are present here,
I'll
have
send
their.
it to you. I'll send it all.
Okay, very good.
Yeah.
Are we on direct examination of Mr. Paul Owings?
We are in the middle of the commissioner's examination of Mr. Owings, and Commissioner Keene is, we're in the middle of his questions for Mr. Owings.
And I'll kind of explain it in an email. So I would just write.
Okay.
Okay. I'm going to hang up now.
Okay, I'm trying to locate Mr. Owings on the screen.
Thank you, Ms. Liska.
Thank you. Yeah, you can pin him.
Oh, there he is. Okay. Yes, very good. Mr. Owings and Mr. Keene is Mr. Keene on the screen?
Yes, it says Commissioner Keene. His camera is off because he's having some bandwidth issues, but you can see his picture and it says Commissioner Keene.
Actually, I'm not seeing a window for him.
I pinned his name. He should come up more prominently.
If not, if Commissioner Keene speaks right now, it might come.
This is Commissioner Keene speaking. Did my square show up?
No, it didn't, but let me mark it so that it'll show non-video participants. Oh, there's a lot of them.
Two on either side of your screen. You can hit those and get to him, perhaps.
Yes, I do see Commissioner Keene now. The volume is a little faint on my end. So,
This is Commissioner Keene. Can you hear me now?
I can see your screen light up.
Can you not hear me? Can you hear me now?
You're pretty scratchy. Pretty scratchy. It's not coming through really good.
Let's go ahead and try. Commissioner Keene, you sounded okay to me. We'll stop if we have any issues with garbling. The volume sounds okay on my end. So Ms. Bates, if it's possible, you may be able to turn your volume up. Why don't we just go ahead and try to begin? We're gonna, I think, we're gonna see how it goes. We may take a very short lunch break here in just a few minutes, but I think we'll go ahead and try to resume Commissioner Keene's questioning of the witness. And then we may take a short break in a few minutes. Are you ready, Ms. Bates, if we begin?
I am. I'm going to change one thing on the view. And I'm sorry, I don't know who has been speaking, asking if I'm ready.
So this is Chair French.
Okay, Chairman French. And your first name is?
Andrew.
Okay.
And then we also have Commissioner Annie Keither and Commissioner Dwight Keene.
And they are not on video, I guess.
Not currently.
So if they speak, I guess if anybody speaks who's not on video, will you identify yourself so at least I'll know who's speaking?
Yes, that's a good reminder. Anytime folks speak up, please identify yourselves for the court reporter.
Okay, thank you. And I appreciate your patience with me getting sort of caught up to speed here.
No worries at all. You were accommodating us.
Okay, thank you so much.
All right, are you ready for me to go back on the record?
Yes, I am.
All right, very well. We are back on the record in the evidentiary hearing of this proceeding, having handed over to a new court reporter, and Commissioner Keene is resuming his questioning of Mr. Paul Owings.
This is Commissioner Keene. Can the court reporter hear me?
Yes, I can hear you very well now. Thank you, sir.
Good. Good afternoon, Paul.
Afternoon, 5 minutes in.
Is As I remember where we left off, you were trying to, I think, articulate the fact that as between the two recipients of the notices to construct, that is Evergy and AEP, that the scope of their jurisdiction stopped at their respective state lines. Is that correct?
Yes.
So basically, it was between the two of them to pick an ending point in Kansas that was just to the west of Caney, Kansas, was it not?
That's the decision they made, yes.
Yes, that decision could have been made that they would go south of Chautauqua, Kansas, couldn't it?
Yes.
Could have been made that they go south of Wellington, Kansas, couldn't it?
They could have made that decision.
Or due south even of the beginning point, which is near Garden Plain substation. Isn't that correct?
Yes, it was their responsibility to choose the interconnect point.
Exactly. So it really kind of begs the question about when jurisdiction begins and when it ends. If we accept the premise that for each of the two, Evergy, their domain is Kansas, AEP, their domain is Oklahoma. And as between the two of them, it was their responsibility to select a route that connected the beginning point selected by SPP to the ending point selected by SPP. Isn't that correct?
Yes, we're connecting Buffalo Flats to Delaware, and it's in 2 states, so they had to coordinate an interconnect point.
That's correct. So we were also talking about this trade-off, because it appears to me that although the line could have run through Oklahoma, may have cost more, may have entailed more time to construct, all of these subject to some degree of conjecture. It could have possibly done that. If it did that, I would suppose that in accord with our colloquy up to this point, there would have been more convenience in an Oklahoma route to the Kansas landowners affected by the preferred route. But in any event, the point I was trying to make was, as between Evergy and AEP and selecting the route, that involved a major trade-off that the two of them made, and there were consequences of that trade-off. The effect of those consequences was that Kansas landowners directly affected by the preferred route, their interests were secondary to the interests of Oklahoma landowners, Evergy's construction timeline, and other Evergy interests.
And other what, sir?
Would you care to respond? Evergy interests.
Thank you.
I don't think that the landowner impacts were contemplated in the decision. I think it related to the schedule, and then, the uncertainty of not completing this within that prescribed schedule. I don't think that, or I have no evidence to suggest that Evergy and AEP made any of their decisions based on Oklahoma landowner impacts or Kansas landowner impacts. I think they selected this route because they thought it gave them the best chance of constructing this line on time.
Should this commission, in determining whether or not to approve this line, consider the impact that this line has on Kansas landowners directly affected other surface users directly affected, and other Kansas landowners not directly affected.
Yes, the commission considers that.
So within the domain of the commission is the consideration of issues that were beyond the purview of anything contemplated by the Southwest Power Pool when it designated the beginning point, the ending point, and decided who the recipients of the notices to construct were. Isn't that correct?
I think that in considering the reasonableness of the location, other considerations by the SPP don't relate to the reasonableness of the location of the line.
I didn't ask that, Paul.
I'm sorry. Could you repeat the question? Then I may have misunderstood you.
What I'm saying is, isn't it within the purview of this commission when determining whether or not to approve the line, we take into consideration the interests of all Kansans in determining the reasonableness of the line?
Yes. Or I would say we take into consideration all Kansans when determining the necessity of the line, primarily.
But not the reasonableness.
The reasonableness, I think, relates more to impacted individuals than all Kansans.
Very well. And is it not within the purview of this commission to consider the impact this proposed route has on Kansas landowners and service users most directly impacted by the preferred route?
Yes, that directly relates to reasonableness.
If important and serious impacts of the proposed line siting are not adequately identified and assessed, how is it possible that they can be minimized?
If important parts of the application weren't adequately assessed, I don't think you could analyze their minimization.
So basically, without an adequate identification and assessment of important and serious impacts this line siting would have, it's not possible to determine whether or not they've minimized impacts theretofore not assessed or considered, right?
I'm sorry, Mr. Keene, you cut out after you said it's not possible to determine whether or not they've minimized impacts, and then it got very staticky on my end. You may have moved away from the microphone or something.
We'll just leave a question mark at the end of that where you have it, to court reporter. Paul?
Sure. If they haven't adequately considered impacts, you cannot quantify their minimization.
Exactly. Thank you. I appreciate that. So if we don't adequately consider viable alternatives to the preferred route, as for example, a route through Oklahoma, how can we say that we have minimized the impacts the preferred route has upon affected stakeholders?
I would say that we're limited to considering impacts within Kansas, and considering impacts in Oklahoma versus impacts in Kansas is not a part of the overall consideration.
Chair French, I would suggest that we've reached I can break here in terms of my cross. You want to take a lunch break and then we can return to my cross
Yes.
when I come back.
If you have additional questions for Mr. Owings, I think it's appropriate for us to go ahead and take a short lunch break here, unless I hear any objection from the parties. Let's just take a 30-minute lunch since we're virtual. Hopefully everybody's got something nearby. So at this time, we are off the record and in recess until 12:45. And everybody please turn your cameras and your audio, mute your audio, turn everything off while we are at lunch. So breaking now until 12:45. All right. This is Chairman French. I have 12:45. We are still off the record, but I just want to check and see if we have all of our parties and our court reporter back. Let's see, I'm looking through the list here. Ms. Bates, are you back from lunch?
Yes, I am. Thank you.
Okay, very good. I see Commissioner Keene. Commissioner Keither, are you back? Commissioner Keither, I don't have you yet. You're muted and your camera's off if you're trying to speak to us. Let's see about parties. I see Miss Hain on camera. I see Mr. Bailey. I see Mr. Smithyman. Mr. Zakura, are you with us?
Yes, I am. Thank you.
Okay, very good.
Chairman, Mr. Buck's with you. I'm here.
You anticipated me.
Yes.
Wonderful. Okay, let's check on Commissioner Keither one more time. Commissioner Keither, are you back with us?
Okay, I'm back.
Okay, very good. I saw you go off mute, so I figured you must be. All right. And Mr. Owings, are you prepared when we resume?
I'm ready to go. Thank you.
Okay.
Okay. Can I ask one thing, Commissioner French?
Yes.
Commissioner Keene, I hear you very well most of the time, but just every once in a while it cuts out. That's when I asked you to repeat, and I don't know if it's maybe you're moving a little farther away from your microphone or something. I was just going to ask if possibly you could make it a point to stay as close to your microphone as you could.
I will. I don't think that's the issue, but I will leave the video off. What I would appreciate much is, can you hear me now?
Yes, right now I can.
If you reach a point where you can't hear me, I'm going to be pretty deliberative in the way I read these questions for your benefit. So if I'm cutting out, you tell me as soon as you can that that's the case.
Yes, that's what I've been trying to do. But
yeah, and I'm having the same issue, Miss Bates. I think it's his internet connection, because yes, it does just go in and out. And so Commissioner Keene, we'll try to stop you, and Miss Bates, yes, you do whatever you need to do for the transcript. If you need to cut in, we certainly take no offense and we appreciate it. So
okay, thank you.
Oh, okay. Anything else before we go back on the record?
One thing, if you think it would be helpful for me to change locations, I can try that and we can see how it works.
You know, the only other thing we could try is to have you just call in on your phone on the number, but given that we are so close to with our final witness, I would suggest we just try to push through at this point. If that's okay with you. If it becomes disruptive, we might try another method. Are you okay with that, Commissioner Keene?
You bet. You bet.
Okay.
You bet. If we have too many interruptions, it won't take but maybe a couple of minutes for me to relocate. So that's not a big problem.
Well, the indicator I see next to your name, it used to say that your internet was red. Now it says it's yellow. So I'm going to say that that's better than it was before. So I think we'll go ahead and try.
Okay.
Okay. If everyone is ready, I'm gonna bring us back onto the record. So this is Chairman French, and we are back on the record in the hearing of this proceeding. And we are continuing with Commissioner Keene's examination of staff witness Owings. Commissioner Keene, you may proceed.
All right, thank you, Chair French. Good afternoon again, Paul.
Good afternoon. Thank you.
Can you hear me all right so far?
Yes, sir.
All right, let's work through this line of questioning here. In citing this line, based upon the evidentiary record to date, Do you believe that the issues pertaining to the environmental and ecological impacts of the line on the Flint Hills that are within the path of the preferred line, you believe that this is an important and serious impact for the commission to consider in deciding whether or not to approve this line siting?
I believe that Evergy has appropriately weighed those impacts within the routing study through standard criteria.
That isn't the question I asked you.
Okay.
I asked her whether you believe that the issues pertaining to the environmental and ecological impacts of the line on the Flint Hills area within the path of a preferred line were important and serious impacts to consider by the commission in deciding whether or not to approve the line. That should be a yes or no answer.
Right. I believe those impacts are an important consideration, yes.
All right, that is a response. Thank you. Do you believe that this matter has been adequately considered by Evergy to date?
Yes, I do, through standard criteria.
How?
They had a number of standard criteria within the routing study to weigh those specific impacts versus other impacts, such as agricultural, residential proximity, etc. And that was a part of their evaluation.
No, I'm talking about present, up to date. I'm not talking about perspective. Is your answer the same?
Yes, they considered those parameters within the routing study. They had standard criteria. Now, there is the matter of environmental reports and permits. So in consideration of those, and I have put a lot of consideration into it, I think there is quite a bit to consider. So historically, those haven't been required. So I don't know that requiring them mid-docket is consistent with what people have historically provided. And personally, I don't know that I would recommend acquisition of permits and environmental studies ahead of time, because I think to acquire those, you must get a very specific, almost survey grade route where you have coordinates on poles, elevations, and have a very firm knowledge of where you'll put it. And my apprehension relates to a decrease in flexibility. So at this point in the process, we have limited flexibility due to the preferred route. We've made modifications to help people. Landowners often even complain that there isn't adequate flexibility. My fear would be if we prepared more extensive environmental reviews and permitting, that we would degrade that flexibility and be locked into a very specific route. Therefore, I conclude that Evergy's consideration of these environmental factors in the routing study with their weighted criteria was adequate.
Well, as things stand right now, aren't we locked into a very specific route, which we generically refer to as Evergy's preferred route? I mean, that's the factual basis upon which all other considerations evolve, is it not?
Yes, the preferred route, but we have staff has proposed 12 modifications.
Okay, with those 12 modifications, we still have a finite route, well identified at this point, do we not?
Yes, we do. Staff's also recommended micrositing, so it could still deviate, but within that corridor, staff's recommended Evergy's preferred mount plus 12 modifications plus microsighting.
Okay, here's my next question. You've answered it in part, I don't think in its entirety, so I'm going to ask it as I've written it. In citing this line, based upon the evidentiary record to date, do you believe that the following issues are important issues for the commission to consider in determining whether or not to approve this line citing? And these impacts include the affected area's environment, its forestation, its wetlands, its historic and historic preservation attributes, its impacts on farming and ranching practices, including the probable permanent disruption of native soils and grasses from the line construction and subsequent activities and operations, and from the location and permanent placement of large line poles.
I think the commission should consider the reasonableness of the route and necessity. A lot of those items, especially the environmental ones and the historic preservation, must undergo permitting requirements with other agencies. I believe Evergy's agreed within the settlement agreement to acquire those permits. We could implement a trust but verified process where we review that those permits have been acquired. But I don't know that we'd need to do such an exhaustive review of it as other agencies who specifically look at those issues. I look at it in the context of the routing study and the weighing of impacts. So the weighing of those important impacts versus other impacts, and trying to have a balanced approach, which is often landowner first oriented in Kansas, to acquiring a reasonable route. And with the knowledge that those permits will be acquired, and if the permits have a detrimental effect on the route, Evergy will have to come back to the commission and modify.
Well, there's an aspect of that question you haven't answered, so I'm going to double back on that. Do you believe that an important issue for the commission to consider in determining whether or not to approve the proposed line siting is the impact on farming and ranching practices, including the probable permanent disruption of native soils and grasses from line construction and subsequent activities, including operations, and from the location and permanent placement of large line poles?
I believe that all impacts, well, not all impacts, but I believe that impacts of that nature should be considered by the applicant when choosing a reasonable location. And I believe that Evergy has done so in their routing study. So it's a matter of weighing those impacts versus other probable impacts. You know, we've heard from oil and gas interests who are concerned about the line being located in developed areas of oil and gas fields. We've heard from property owners who have undeveloped areas who would prefer it in a developed area. We have farming and ranching who are concerned about those impacts. It's important to consider all those impacts and try to balance them to get a reasonable location. And in my opinion, Evergy has done that in the routing study.
So you believe that these matters have been adequately considered by Evergy to date?
Yes, I believe Evergy's completed their routing analysis based on the guidance document, and I believe their routing analysis is substantially similar to others completed on line siting dockets in the past.
You believe that includes these farming and ranching practices to which I've referred?
Yes.
Next question. In citing this line, based upon the evidentiary record to date, do you believe that the impacts the proposed line would or will have on oil and gas related activities throughout the 4 counties affected by the proposed line are important impacts that should be considered by the commission in determining whether or not to approve the proposed line siting?
I believe that oil and gas impacts are important.
Do you believe that the impacts on these important oil and gas related activities have been adequately considered by Evergy to date?
Yes, I believe they have, based on the testimony of the Burns and McDonald witness. I think his name was Dunham. They have a proprietary database where they reviewed existing oil and gas wells, and they
being recorded.
endeavored to cite those the proposed lines, the segments and areas where oil and gas wells did not exist, and they conducted field visits where they further reviewed and analyzed for existing infrastructure. Connection.
We've still got you, Paul. I'm checking to see if we still have Commissioner Keen. Oh, we still have him, but he is on mute.
Well, the machines, somebody, can you hear me now?
We do hear you.
Yeah. Court reporter, where did you lose me?
I got all of Mr. Owings' last answer. You said, do you believe that the impacts on those important oil and gas related activities have been adequately considered by Evergy to date? And I got all of Mr. Owings' answer, and then I didn't hear anything else from you.
Okay. I'm going to respond to Mr. Owings' answer now, if you're ready.
Yes, sir.
Okay. So you believe that they have adequately considered oil and gas related issues, notwithstanding the fact that neither the witness from Burns McDonald, none of the Evergy witnesses were able to identify with any specificity that there were more than 2 oil and gas leases out of this entire 4-county area. They couldn't identify with specificity all of the oil and gas leases that were affected, all of the oil and gas wells that were affected, the injection and disposal wells that were affected, the abandoned wells that were affected, the environmental consequences of all of that, and that they basically had conducted what appears to be a very perfunctory review of the oil and gas impacts.
I believe that the routing guidance document had a principle that stated that applicants should avoid direct impacts to existing oil and gas infrastructure. And I believe that's what Evergy did and considered. The finding all of the leaseholders and notifying them, I think is, notice is somewhat of a legal matter and standard. Do I think that communication is beneficial? Yes. Do I think additional efforts could have been put forward? Yes. And that may have decreased risk for Evergy when after this docket, they try to microsite this through these oil fields. But based on the line sighting guidance document, I don't think those steps were required to be complete ahead of time.
So your answer, it appears to me, totally disregards the fact that, as testified to by staff witness Haynes, Evergy has failed, notwithstanding the routing guides, has failed to comply with important parts of what is not just a mere formality, but the protocols developed in due course by the KCC with regard to oil and gas and all of the actions that need to be taken there. Obviously, it's clear that not all of those have been absolutely adhered to. Am I wrong?
You're right that Mr. Haynes made some statements about this, but I'm looking at the protocol right now, and the Evergy protocol that the commission approved in the grain belt docket, and it says during the routing study phase of project's development, Grain Belt Express will seek to identify existing oil and gas production infrastructure on parcels within the study area. I believe Evergy has sought to identify those, and only after a route is approved do they use good faith efforts to identify oil and gas operators with production interests on parcels within the project's right-of-way and negotiate those items. This was contemplated in the general investigation. Tioga and EKCE both requested that notice be issued. I'm not going to make a legal determination on the notice, but I would say that it hasn't been required in the past. And they compared routing through oil fields to the impacts to cultivated fields, where it should be minimized when possible. However, I think they acknowledged that completely avoiding impacts in oil fields was not possible. There was a number of transmission owners who spoke to that. Sunflower Electric out in Ellis and Russell and Rooks County, where there's a lot of oil fields, have to navigate these issues. And if I recall, no evidence was put forward in the general investigation where transmission lines had significantly impacted oil and gas interests. And then the last thing I would state is that the transmission intervenors in that docket pointed out they have an intrinsic motivation to not impact oil and gas wells, lest they be subject to damages or claims against them because they've decreased production. For those reasons, when we wrote the protocols, we narrowed it down to the one principle about avoiding existing infrastructure. Burns and McDonnell witness Dunham indicated they located that infrastructure with their proprietary software and did field visits. While he couldn't produce an exact number on the stand, I think they've met that requirement.
The oil and gas protocols in the Evergy matter on Grain Belt predated the protocols of the KCC, did they not?
I think those are the ones that we referred to, the Evergy ones. They're one and the same.
What do you mean the ones we referred to? I don't know what you mean.
Evergy produced these protocols, and within our R&R, we referred to Evergy's protocols as a minimum requirement. And then within the commission order, these specific protocols were referred to again. I don't think there is a separate commission protocol.
Yeah.
Mr. Owings, I'm I'm sorry, I didn't understand the name of, I don't think you were saying Evergy, but I don't think you were saying energy. It was a proper.
Invenergy, it's INVENERGY.
Thank you.
Well, I'm honestly trying to follow your train of thought, and I'm lost. The
Commissioner
Evergy
Keen, you broke
protocols
up.
that were
You
part.
broke up, Commissioner Keen. Could you just go back to the beginning of that question?
Can you hear me now?
Yes.
The Evergy protocols that were part of the Grain Belt line protocols predated the commission's development of its protocols for oil and gas, did it not?
The commission didn't develop oil and gas protocols. We developed the line siting guidance document, and within the R&R recommending the line siting guidance document, we referred to Invenergy's protocols and said a statement that they could be viewed as a minimum standard because the utilities were worried about the minimum requirements of oil and gas protocols. Then within the commission order, a statement was made that the Invenergy protocols would be the minimum standard or should be the minimum standard.
Return to the routing study. The routing study phase of the project precedes the siting of the line, does it not?
Yes, it does.
And in accordance with the KCC docket 24-102, which incorporated by reference protocols within docket 24-790, as I read it, these protocols state that the utility proposing a new transmission line will perform certain actions during the routing study phase. One of these is that they will seek to identify existing oil and gas production infrastructure on the parcels within the study. Isn't that correct that that is an important aspect of the routing study phase of the project?
Yes, that is correct.
You believe that in this case, Evergy really sought to identify existing oil and gas production infrastructure on the parcels within the study?
Yes, as stated by John Dunham, Burns and McDonald has a proprietary database which probably has data sources above and beyond KGS. It would be a good question for him. They considered these existing oil and gas infrastructure as a part of the study, and then they performed further work by doing field visits to look and identify infrastructure. So I believe they've sought to identify existing oil and gas production infrastructure.
Your recollection of his testimony is quite different from mine, because I don't recall that he provided with any specificity whatsoever, even generically, aside from these proprietary claims you're making that he has some claim to. There's no evidence on the record that anyone on behalf of Evergy in this docket that I know of has identified the number of leases, the number of wells that are impacted by the route of this line through 4 counties. Am I wrong?
I do not believe.
With specificity. I'm sorry, with specificity.
You are right. I believe they did not produce a specific number and count them, but I believe they were considered.
How can you conclude they were considered without them providing at least some element of specificity in response to commission questions in this hearing?
Because he stated that they considered them.
Let's turn to page 34 of your testimony, Paul.
Okay, I'm there.
I'm looking specifically on page 34 at lines 14 through 20. And for the record and the benefit of those listening in, I will read back your testimony as it appears here on page 34.
On page what, sir? As it appears on page what?
34.
Thank you.
Beginning on line 14, the question is, what was Evergy's justification for the preferred route? The answer, beginning on line 15, is, according to Evergy, the preferred route was determined to balance the issues and number one, and concerns for a new transmission line and minimize the overall impacts to social and natural resources while providing a constructible economic route, period. Specifically, comma, the preferred route achieved a balance between minimizing residential proximity, comma, maximizing length within or parallel to existing infrastructure corridors, and three, weighing the benefits of cross-country paths against those that paralleled roads and parcel boundaries. Paul, did I accurately restate your testimony on page 34?
Yes, sir.
And these are Evergy's justifications for the preferred route. Yeah,
Yes,
I find.
Oh, sorry.
Go ahead. No,
I was going to
you
say,
have a
yes,
comment?
they are. Yes, they are. That was based on data requests and their application, I believe.
Yeah, fair enough. Appreciate the source. So their specific concerns are balancing between minimizing residential property proximity, maximizing the length within or parallel to existing infrastructure corridors, and weighing the benefits of cross-country paths against those that parallel roads and parcel boundaries. That is lines 17 through 20, correct?
Correct.
And I have read into the record the totality of your answer to the question, what was Evergy's justification for the preferred route? Have I not?
Yes, you have.
I find no reference within this justification or no specific reference to any concerns about the Flint Hills or how to manage impacts to the Flint Hills. Do you see any of those?
No, I do not.
I see no specific references to studies concerning important environmental, historic preservation, or other social issue impacts before selecting the preferred route. Am I correct?
You're correct.
Furthermore, I see no references to recognizing, preserving, or protecting the environmental and economic interests in the four-county area of a major Kansas oil and gas, a major Kansas industry, that is the oil and gas industry. Am I correct?
You're correct.
And I think I'm about there. Turn to page 37 and I'll ask you my final. Well, no, I won't. I'm going to skip page 37. A few more questions and I will be done. In transmission line sighting matters, if important and serious impacts of the sighting are not adequately identified and assessed, they cannot be minimized. Is that correct?
If important aspects of a line sighting docket are not considered, they cannot be minimized.
Are not adequately identified and assessed, they cannot be minimized.
Correct.
Is that correct?
Yes.
Okay. If important aspects are not adequately assessed and minimized, there cannot be a factual basis for concluding that they are reasonable and in the public interest. Isn't that correct?
I believe that's a legal evidentiary standard that I'm not familiar with.
Are you telling me within the context of all matters incidental to this document, you haven't considered the adequacy of impacts or whether or not they've been minimized without being a lawyer?
I've considered them and I concluded that they were adequately addressed for this stage of the project. It's a multi-phase project. I believe a lot of the concern with these other factors will occur at other phases. Looking on page 37 where we're at, there's about 10 or 11 or 12 other agencies that Evergy has to get permits through, where a lot of those items will be addressed. And I think the one, though, that stands out is impacts to the Flint Hills, which they did not have a criteria, but I would say this. I designed a criteria for impact to the Flint Hills. It would be length within the Flint Hills. I believe Evergy witness Loveless said this was the shortest route in the Flint Hills. Therefore, it would have scored favorably for Flint Hills impacts.
Yes, but the scope of his inquiry was confined to Kansas, wasn't it?
Yes.
I appreciate your answer, Paul. It was granular, but it didn't answer the question. The question I asked was quite specific. I didn't ask whether you believe that they had satisfied these impacts. My question is, if important impacts are not adequately assessed and minimized, there cannot be a factual basis for concluding that they are reasonable and in the public interest. Isn't that correct?
I think so, yes.
So, unless the important line sighting impacts are identified, assessed, and minimized to the commission's satisfaction in advance of line sighting approval, any commission approval is premised on speculation, promise, and hope, and not on fact-based analysis. Isn't that correct?
Again, that sounds like a legal standard and is beyond my evaluation. I found the evidence to be adequate personally, but if those items hold true, then that could be decided by the commission.
Fair enough. Under such circumstances, where commission approval preceded an adequate identification, assessment, and minimization of impacts, isn't it true that the utility, not the commission, becomes the arbiter of the adequacy of their own efforts to assess and minimize impacts without any before the fact, independent commission oversight, accountability, and approval?
I'm trying to get my hands around that. So the utility is the arbiter of the, I'm sorry, could you repeat the question?
I'll try to rephrase it, Paul.
Okay, thank you.
If the commission doesn't determine to its satisfaction in advance of granting wide approval that important line sighting impacts have been adequately identified, assessed, and minimized, the commission no longer becomes the arbiter of the adequacy of Evergy's efforts to assess and minimize impacts because they fail to conduct a before the fact, fact-based oversight, accountability, and approval process.
The commission could make that conclusion, or they could add conditions that obligate Evergy to meet any requirements that they believe weren't adequately addressed within the application.
But if the impacts are significant, consequential, and important, wouldn't it be better to head those off before the fact than after the fact?
I think the commission would have to weigh those two scenarios and determine whether it was better or not.
Okay, fair enough. Paul, I appreciate your indulgence of my questions very much. At this time, I have no further questions.
Thank you.
Okay.
Thank you.
Thank you, Commissioner Keen. Commissioner Keither, any questions of this witness?
Yes, thank you. Good afternoon, Paul.
Good afternoon, Commissioner.
Commissioner Keen just took so many questions right out of my mouth, right at the end there. My concern was going to be about the historic and environmental impact that is going to be having on this line going through Kansas and specifically the Flint Hills. And, you know, my question was, shouldn't the commission, whether or not the commission should or should not place considerations or conditions on the line to consider those impacts? And if not, why not?
Within my testimony, I argued that the agencies responsible for those specific issues should regulate those agencies. For example, there was references to Section 106 of the Historic Preservation Act.
Right.
You know, the commission staff aren't familiar with those specifics. Evergy is obligated under law to meet those. They've agreed to meet them within the non-unanimous settlement agreement. We could bolster that and require a trust but verify approach where Evergy gets those and files them with the commission.
Mm-hmm.
I would suspect that we would review what the other agencies had said, and I wouldn't.
Mm-hmm.
I also made the argument that we wouldn't necessarily go above and beyond what their determination was, and we shouldn't add conditions that were within their purview.
Do you think, in your opinion, do you think that the commission is responsible to be stewards of the land?
I think that, you know, the commission's mission is to protect the people of Kansas by regulating utilities and energy infrastructure. I think there's an aspect of that, especially within the conservation decision. I think that, you know, public utilities have a high standard of care they must operate under, and that includes minimizing impacts to the land. Within line sighting statutes, there is one that the utilities must restore property to pre-existing conditions. And, you know, we handle complaints relative to that and make decisions and can oblige the utilities to continue restoration. So I think that's an aspect, albeit in the context of the statutes that our, our agency operates under.
Mhm. Okay, that's all I have. Thank you, Paul.
You're welcome.
All
Thanks.
right. I think I've got a few questions for you, Paul. Good afternoon.
Good afternoon.
I'm sorry, who is speaking, please?
My apologies. It is Chair French. We are still on commissioner questions. Are you ready, Ms. Bates?
Yes.
Okay. So I do have a few questions for you, Paul. I was surprised by your Q&A with Commissioner Keither just then, because I think she asked you whether it would be appropriate for the commission to place conditions on an order in this proceeding that would protect the environment. And you sort of referred to other agencies and made some other comments, but as I understand it, you actually have proposed a condition to protect the environment here, and that is for Evergy to be required to hire a separate third-party consultant to ensure appropriate remediation techniques. Is not correct?
That is correct. I'm maybe having a little fatigue here on the stand, but I made that recommendation because after the public hearing, and a lot of the concerns about the Flint Hills came about, I acknowledged that a utility has restoration obligations, and we have an ecosystem that is sensitive, and I would like, personally and as a state employee and as a resident of Kansas, to preserve the Flint Hills and have first-class restoration of the Flint Hills. So I thought that recommendation was consistent with that, to basically ensure that Evergy is meeting their restoration requirements.
I mean, I'll be honest. That was the type of condition I was already starting to think about before I even read your testimony in this case. I mean, you can tell through some of the questions I've asked. I mean, if we were to allow the line to proceed, remediation is terribly important to me. I guess what I'm still thinking about, though, is whether there are opportunities to enhance that condition if this were to move forward. Can you tell me how you came up with the recommendation that Evergy would be the one with the relationship with this third-party consultant rather than staff or the commission having some more active role in that process?
I think I just made an assumption that they would be the person to do it. And I guess, I've been at the commission now 2 years and 4 months. I wasn't aware that we took on consulting, things like that, but I feel like there's a lot of value in us doing it because we could be involved in the selection, and it kind of creates a firewall between the person, the consultant would be working for Evergy, and if they're working for the commission, you could potentially get better results. So I guess I hadn't contemplated that, but I think that's a reasonable request considering the concern and nature of the Flint Hills.
Yeah, I think we need to consider what that arrangement looks like, and I'm not sure if well, now is probably not the time to figure that out, but perhaps there could be even if the relationship is between Evergy and the consultant, perhaps there could be a process where at least an approval process where the commission could sign off on that individual. It's hard to say it's a good or bad idea when we've got no control over it. So I'm just thinking out loud, and I apologize. Let's shift back to the discussion of that you were having with Commissioner Keene about the pros and cons of considering a route through Oklahoma as opposed to Kansas.
Sure.
And I want to look specifically back at page 25 of your direct testimony. And it was the Q&A that starts at line 10 of page 25.
Okay.
And I believe at that place, you were describing the fact that there are sort of a list of items that I guess you said that we wouldn't have any benefits in terms of cost, schedule, or amount of land impacted by going south. That the only benefit that you could see in your testimony was basically that we could remove the impact to Kansas landowners whose properties were impacted. Is that correct?
Yes, that's correct.
Is it safe to assume that if we went south to Oklahoma first and then over east to the Point B substation, that we would basically be trading a set of Kansas landowners for a set of Oklahoma landowners to be impacted?
Yes, precisely. In fact, it may be longer, and it would definitely affect a longer length and potentially more property owners too.
So
just because you don't have any angular nature of it, it would be more squared up.
So in your mind, at best, the impact on landowners is probably a wash. You're just trading Oklahoma landowners for Kansas landowners. Is that correct?
That's correct.
As I look at the route of the line, it looks pretty direct to me. And it seems like it would be less direct, as you mentioned, to go through Oklahoma. Let's take the timing piece out of this. I know there is urgency on the part of the grid planner, Southwest Power Pool, to get this line in service, but let's assume that Evergy and AEP have whatever time they need to select a route and get the line constructed. Would it be your expectation that the route that is currently proposed is probably going to be the same route proposed even if they had additional time?
I could see them taking the Osage Nation into consideration regardless.
I'm sorry, taking what into consideration?
The Osage Nation reservation.
Thank you.
Regardless. Honestly, I think it would be a little bit imprudent if a utility completely neglected the existence of a sovereign Native American tribe. I think that when you're building a large infrastructure project, that is something that probably any other utility would take into consideration, regardless of schedule.
So just to make sure I understood that, I don't mean to ask the question again. As I understood it, your answer is that Evergy and AEP would be just as likely, even if they have additional time, they would be just as likely to try to avoid that particular area, even if they had more time.
I wouldn't be surprised. Yes, I think I don't know if it would be just as likely, but there's still a very good chance that they would avoid that particular area due to the complexity of siting it. And, just anecdotally, I've heard about wind projects that are midway in on sovereign Native American grounds that are being shut down in different things. So I think there are additional considerations when you seek to build a large infrastructure project on these lands.
I hope this next question doesn't come across as rhetorical, but I want to be real clear on how staff viewed its role or views our agency's role in this proceeding. Do you believe it is? Did you take the position that you needed to come up with a particular route, or did you take the position that you needed to evaluate the route in the application for its reasonableness?
You took the position that you need to evaluate the route in the application for reasonableness. You know, the modifications were based on public comment and close coordination with Evergy, where it was, I guess, mutually beneficial for everyone. So we took the position that Evergy proposes the route and we evaluate the reasonableness.
And we evaluate what?
Reasonableness.
Thank you.
Apologies for the silence. I'm still thinking. I don't believe I have any more questions for you, Mr. Owings. Thank you very much for your testimony. We will now turn to the interveners for questions. And first on my list, I believe I have counsel for the landowner interveners, Mr. Jim Zakura.
Thank you very much, Chair French. Mr. Owings, good afternoon.
Good afternoon, sir.
I can't see you, but I see a sign that says KCC staff. Let's talk a little bit about Osage County, Oklahoma first. First of all, they do have electricity in Osage County, correct?
As far as I know, yes.
And so someone is delivering that electricity to Osage County, correct?
Yes.
And Osage County includes part of northern Tulsa, correct?
I don't know where the county lines are.
Okay. Have you investigated whether or not AEP, which operates in Oklahoma as Public Service of Oklahoma, provides electric power in Osage County?
No, I haven't.
So do you know whether or not the Southwest Power Pool operates a transmission system in Osage County?
I believe they do, yes.
So would that indicate to you that it is possible, and in fact, it happens every day, that a high voltage transmission line is operated in Osage County?
Yes, it's possible.
Would you say it's possible, or is it a fact that SPP operates a high voltage transmission line in Osage County?
I believe it's a fact, but I haven't specifically looked at the county.
And what is the definition of a high voltage line for SPP?
I don't know. High voltage, I think there's a definition for extra high voltage, which is 230 kV above, I believe. And then high voltage might be 115 to 230. I'm kind of going off of memory here, but I know the 345 kV line is extra high voltage.
And have you plotted on the map where the SPP high voltage lines are in Osage County?
I haven't plotted them, but I believe there's maps in the record that SPP is produced with those lines.
Would you describe yourself as being an expert on the Southwest Power Pool?
No.
I didn't hear your answer, sir.
No, I wouldn't say an expert.
Are you on committees at the Southwest Power Pool?
No.
Have you ever been on a committee at the Southwest Power Pool?
No.
Who on the staff is on a committee at the Southwest Power Pool?
The only one I'm aware is the director of the utilities division. His name is Justin Grady.
Justin who?
Grady, Grady.
Thank you.
One thing I noted in this case is that you did not send any information requests. Would that be accurate?
I would say that I wrote numerous ones that did not go out under my name, and we collaborated when they went out. I personally wrote a lot of them, and you know, in the interest of efficiency, I had somebody coordinate their transmittal.
So are you saying that you wrote the information requests that went out for under the name of Mr. Hanos?
No, primarily Matt Galeo.
Okay. And the testimony of, I'm not sure I can pronounce this last name correctly. Would you say it again, please?
Galeno.
And his testimony is related to microsighting in its entirety. Is that correct?
Yes.
Okay. Well, let me ask you this question. Did you prepare 100% of the testimony that you submitted, written testimony that you submitted in this case?
Yes, I did.
You mentioned Mr. Grady. Did Mr. Grady review that testimony or offer comments?
Yes, he did. He's my direct supervisor, so he did.
And could you describe what areas that he offered comments and what those comments were?
I think I went through 4 rounds of comments, and recalling his specifically, they just strengthened the wording and flow of the document and didn't affect positions, more so just made the plain language clearer to read.
One part of your question, Mr. Owings, is not here. You said, did you say how many rounds of review of the testimony?
At least 3 or 4, you know, Mr. Hanos reviews my testimony, Mr. Grady, several attorneys.
Let me ask you, do you understand the statute is stating, the applicable statute is stating that the commission must determine the necessity for and the reasonableness of the route selected?
Yes, I'm aware of that.
Did you conduct any independent research on the issue of the necessity of the project?
Yes, we analyzed the SPP's ITP primarily. I didn't produce a power flow model or anything, but we analyzed the ITP.
So let me see if I can restate that. You didn't, when I say independent research, you didn't do power flow studies, you didn't do anything independent that was not first initiated by the Southwest Power Pool.
I'm going to need to object. This witness has already answered that staff thoroughly reviewed SPP's integrated transmission plan.
Mr. Zakura, can you you can just, I'm not sure I heard your question exactly. Could you just say the question again and then respond to Ms. Hain?
Certainly. The question was, you did not do any independent analysis such as power flow studies or anything else. Instead, your analysis was limited to a review of the SPP research and analysis.
Any response to Ms. Hain's objection?
I don't believe it was asked and answered earlier. I believe I was confirming my understanding of this answer.
Mr. Owings, you can answer the question. I'll overrule the objection.
So the SPP does power flow models in their 14-state region and has proprietary data that we don't have access to. And I don't think there's any history or capability of commission staff to complete and replicate the SPP's power flow model in the middle of a docket with a short time frame. So no, we did not produce a power flow model.
Could you please expand on your answer to this effect? Would you state what part of the analysis that SPP conducted that was proprietary in nature?
I think it's the data related to load and power consumption and generation and location. And it probably also relates to the way they dispatch energy in the market and constraints. It's incredibly complicated. As you know, this would be a great question for SPP witness Raheem, but it's a 14-state region with interconnects with other states. I think there's a significant amount of data there that's just not publicly available.
So would it be fair to say that when you reviewed SPP's analysis, you were reviewing their conclusions and were not able to go behind the conclusions and review the source data?
We didn't replicate the source data, but we didn't just review their conclusions. There was a number of conclusions they made. Like, for example, there was block quotes within my direct testimony where they, highlighted benefits to Missouri, and we critically reviewed those to ensure that there was also benefits in reliability standards in Kansas. So we asked SPP numerous discovery requests to expand upon the initial evaluation, and we reached independent conclusions for ourselves based on both the original evaluation and the additional data we received in data requests.
Let me touch on a couple of things that you said in your prior testimony today and confirm some things. SPP never declared a load shed, did they, during Winter Storm Elliott?
I believe the local grid operator did, but subject to check.
But my question is, SPP never declared a load shed event during Winter Storm Elliott, did they?
That's my understanding, subject to check.
And in fact, the only load shed that SPP has declared in 20 years was during Winter Storm Uri. Is that correct?
I don't know.
Describe for me what the Buffalo Flats project is.
Well, I within the context of my testimony, the Buffalo Flats project was the line from the Buffalo substation to the Oklahoma border. The Buffalo Flats to Delaware would be from the Buffalo Flats substation to the Delaware substation in Oklahoma.
Now, as I understand your testimony, sir, you indicate that SPP did not do a specific analysis or cost-benefit analysis of solely the Buffalo Flats project. Is that correct?
Well, the Buffalo Flats project, based on my definition, ends at the Oklahoma border and wouldn't have transmitted electricity anywhere. But I think, in considering the Buffalo Flats to the Delaware portion, they didn't look at that line as a singular project. They looked at that as one segment to the Branson 345 overlay.
And what is included in the Branson 345 overlay project? That's on page 3 of your testimony, sir.
I believe it's a transmission line from Buffalo Flats to the Delaware substation, to the Monette substation, to Branson substation.
And how many miles is that?
I don't know the total length of all the segments.
But it's considerably longer than the Buffalo Flats project mileage. Is that correct?
Yes.
I didn't hear your answer, sir.
Yes.
Okay. So would it be correct to say that SPP did not study any cost benefits other than of what you described as the Buffalo 345 kV overlay project.
The Branson 345 kV overlay.
Excuse me, let me restate my question. So would it be accurate to say that the Southwest Power Pool did not do any cost benefit analysis of the Buffalo Flats project, but instead only did a cost benefits analysis of the Branson 345 kV overlay project?
Yes. That's my understanding.
Now, I think you indicated that you conducted or you inspected the proposed route. Is that correct?
Yes, we reviewed the Evergy's preferred route.
And how much of that route did you drive and how much of that route did you walk? What did you physically go out and look at?
I can't give you a mileage, but staff witness Galino and Hanos drove portions of the route.
Did you drive portions of the route?
I did not.
Did you walk any portion of the route?
No, I did not walk the route.
Would you agree with me that certain parts of the route, the proposed route, are inaccessible except through walking?
I don't know.
Okay. Would you agree with me, Mr. Owens, that oil and gas business is an important business in Sumner, Cowley, and Chautauqua counties?
Yes.
Would you agree with me that hunting and guided wildlife tours are important businesses in these three counties?
I don't know. I presume yes.
Would you agree with me that tourism is important in these three counties?
I believe that was part of the moratorium. Yes, tourism was mentioned.
Let me ask you this. Have you done, well, first of all, I think you indicated that there is, now let me rephrase that question. Do you recall that part of the testimony of the Southwest Power Pool where the Southwest Power Pool indicated that there would be $2 million per year of fuel savings with the Branson 345 kV overlay project? Do you recall that part of the testimony?
I believe that it wasn't fuel savings. It's that the ITP model forecasts $2 million per year in congestion relief.
Okay. Do you know in what manner the $2 million in congestion relief was calculated?
The ITP model.
Can you be any more specific as what the process was as to how the $2 million per year in congestion savings was achieved?
I would suspect that the model would have to iterate over a given period of time to see how much congestion was decreasing and how much more cheap energy could be distributed to Southeast Kansas. And, you know, that would be aggregated over the course of a year. And that calculation would occur based on some sort of iterative model, but I'm not that familiar with the power flow model where I can say it with certainty.
So would you say that you're talking in terms of the supposition, or my term would be speculation, and not presenting any kind of a factual analysis?
I believe that the SPP did calculate it, and that is factual.
But I'm asking you did not, you haven't seen that, how they calculated, and you cannot state personally how that was calculated.
I did not personally calculate it.
And you have not seen how it was calculated.
I have not seen the power flow model visually or.
And is that because that is a proprietary program?
I don't know if looking at it is prohibited, but I think the data that goes into it is somewhat proprietary.
For that $2 million of congestion benefit per year, what is the cost per year that retail ratepayers will be asked to pay?
I don't understand your question. Could you please restate it?
Certainly.
Reword it, excuse me.
If the benefits for Kansas, or let's say just, first of all, of that $2 million per year in congestion benefits, how much of that will be realized by Kansas retail ratepayers?
That specific number was for Southeast Kansas. So that would be, it's my understanding that 100% of the 2 million is for Kansans. That's a Kansas benefit.
Okay. And for that particular Kansas benefit, what is the cost that will be incurred by SPP retail ratepayers to generate that $2 million of congestion benefits per year?
I don't know the cost of SPP ratepayers to generate. Well, I guess, let me restate it. Ratepayers don't generate that $2 million. That $2 million occurs because congestion is relieved. Ratepayers will have to pay for the cost of the transmission line. Those are two separate things.
What's the cost of the transmission expense that retail ratepayers will have to pay in order to realize the $2 million annual benefit?
Retail ratepayers where, in Kansas, or, they allocate the cost of the whole project. I'm more familiar with the Kansas portion, Mr. Zakura. I think it was like $3.34 for the Buffalo Flats portion will be the impact to Kansas ratepayers, or something, or Evergy ratepayers more specifically, but I don't know if there's any variability with that for other utilities within Kansas or elsewhere, or I haven't totalized that cost either.
Well, let me break up the question if I could. I understand from your testimony that Kansas retail ratepayers in Southeast Kansas would receive a $2 million per year congestion benefit. Is that correct?
That's correct. I guess it's estimated through the ITP model, yes.
What is the cost that would be paid, first of all, by all retail ratepayers, the total cost, not cost per month? What's the total cost to achieve that benefit?
The total, are you talking about the total cost of the Branson 345 project?
I know I'm talking about the portion of the cost of the Branson 345 overlay project. What portion of that cost relates to the congestion benefit of $2 million per year?
I don't know.
Do you believe cost benefit analysis is important before spending retail ratepayers' money?
I believe that for an economic project, a cost benefit analysis is important prior to spending ratepayers' money, but this was a reliability project. And then when you're considering a reliability project, I believe cost benefit is handled differently. We're violating federal reliability requirements. So any cost benefits or any cost benefits are additional in addition to the reliability.
Now, you talk about violations. No federal agency has issued any violations to Evergy or SPP for their operations in Kansas, have they?
These are violations. They're voltage and thermal violations. So it's my understanding that NERC, a thermal violation is your transmission line is getting too hot. So they set limits on the temperature range you want to operate it in based on the current. Voltage violations, as you push more power over the grid, the voltage drops. So the violations weren't some sort of regulatory violation. They were a violation of engineering standards that are required to reliably operate the grid.
And would you agree with me? Well, let's take them one at a time. Is there any evidence in this record of any thermal violations other than during the whatever period we're talking about here. Is a 1-day period of Winter Storm Elliott?
I'm sorry, a what day period?
I said 1 day.
Thank you.
I don't know if I know thermal specifically, but I seem to recall a data request where SPP stated that these violations have occurred multiple times. I don't know if they qualified whether it was thermal or voltage. So this isn't a singular event when the grid was operating above its capacity. That's my understanding.
Let me ask you this question. Mr. Owens, is Evergy supplying efficient and sufficient service in Kansas today and during the period of Winter Storm Elliott?
I believe that Evergy does provide efficient and sufficient service, but I also believe that the electric transmission line system is stressed. So they're providing that service under stressed conditions. And this goes back to SPP witness Rahim's testimony. The way I interpreted it is it was a near miss for Kansas, where if weather patterns would have been different, if the Arctic cold would have lasted longer, then Kansas could have had load shed.
If I might, Chair French, I would like the witness to directly answer the question. He can give a full answer, but he's answering a question and then offering his own interpretation or extension of the answer, which should be left up to his counsel on redirect. I would ask the chair to direct the witness to answer the question fairly, accurately, and completely, but not to go on with additional information.
If I might interject.
If I might interject, I would say that the question that Mr. Zakura is instructing the witness to answer is a legal conclusion. He's asking him to opine on the efficiency and sufficiency of the service that Evergy provides, which is directly quoted from Kansas statute.
Can I respond to that?
Sure. Please go ahead.
It's not asking for a legal conclusion. That's the standard for which he is the director of, gotta get his title right. He's the chief engineer of the commission. If he can't operate and give an answer that's not a legal answer under that, I don't know who in the world could.
So I personally did not find anything offensive or deficient in Mr. Owens' answer. It sounded like he was trying to give you nuance of how he was thinking about it. But I also I'm also not going to object on an asked and answered basis if you want to drill down with him farther on his answer. So I will. Let's see who objected here. I'm going to overrule the objection. I guess we did not have an objection. We asked for counsel to direct for me to direct the witness to answer. So I'm not going to do that. But Mr. Zakura, if you want to re-ask your question a different way to try to get additional information, that is certainly fine.
Chair, there was an objection to calling for a legal conclusion in the answers. I think you probably addressed that, but I just want the record to be clear.
Yeah, I do think that it is a legal conclusion, which ultimately is up to this commission in most cases. But the witness is a seasoned member of commission staff, and if he feels that he can offer a direct answer, then he can answer that. If he feels that his answer requires more nuance, I don't think it's unfair to let him explain his thought process on it. So I'm going to overrule that objection. Thank you, Mr. Fedotin.
And that speaker was whom? That
Mr. Brian Fedotin, who is General Counsel of the Kansas Corporation Commission.
And that's FEDOTIN and Brian with an I.
Thank you. And Ms. Hain, since I'm talking here, if I can ask you to speak louder when you make comments, it's pretty hard for me to hear you.
Yes, will do. Thank you.
Thank you.
So I believe we're ready for Mr. Zakura to continue. And if you want to drill down on that last question more, please feel free.
Thank you, Chair French. Mr. Owens, has the commission staff proposed any citations to Evergy for its failure to provide sufficient and efficient service?
Not that I'm aware recently, maybe sometime in history.
Let me rephrase the question. In the last 2 years, has
Not that I'm aware.
Okay. Mr. Owens, I would direct your attention, please, to page 7 of your testimony, beginning on lines 4. You state the primary consideration is necessity of transmission line to connect supplier facilities to suppliers' customers. Do you see that, sir?
Yes.
Which Evergy facilities are you speaking of, and which Evergy customers are you speaking of?
I think that was just a description of the primary consideration in a TRO certificate. That statement doesn't speak about specific connections.
So would it be correct to say you're speaking more philosophically than specifically?
That specific statement, the primary consideration within a TRO certificate docket relates to the necessity of a transmission line to connect the supplier's facilities or those of others to serve the supplier's customers, is a description of what staff typically considers in a TRO docket. So the reader of my testimony understands that it's some background information.
Well, let me ask you a question, drilling down a little bit. Does the Buffalo Flats project deliver any electric power to any Kansas customers?
Yes, it will. It can either come it could come via any of the substations. It could come from the Buffalo Flats substation and go into Garden Plains or Goddard or Wichita or further down into southeast Kansas. It could push from the Delaware substation up through Oklahoma and into southeast Kansas. It could probably even flow from Missouri into Kansas. So it will ultimately provide power to Kansas.
The Delaware station, who owns that?
Subject to check to AEP.
AEP does not deliver to Evergy customers, does it?
AEP does not have retail electric service with Evergy customers, but electricity can come off of their infrastructure into Kansas.
But AEP does not deliver to Evergy customers, does it?
I answered the question. When you say it does not deliver, I'm assuming you're saying, does any power generated by AEP enter Kansas's electric grid? And I would say that it's very, very probable that it does, considering the connections.
Does Evergy deliver any direct, does AEP, or in this case, Public Service of Oklahoma, deliver any retail electric service in Kansas?
No. Retail electric suppliers in Oklahoma provide service in Kansas. Oh, well, I guess they could be in both states, but I'm not aware of any.
Let me direct you to page 7. You say the TRO order. Now, first of all, what's the TRO order?
Transmission rights only.
And you say the TRO order supports the necessity for the proposed transmission line in this case. What do you mean by that?
Well, within the TRO application and the report and recommendation, we in part analyzed the necessity of the line, and the commission conditionally approved it. I wouldn't say it, so I'd say that is support of necessity.
Let me ask you this. Do you think that the TRO order, and as you say, supports necessity, has determined necessity in this case?
I didn't, I would say, no, I didn't determine it. It's supportive of the case.
Is it strongly supportive, weakly supportive, or what would you say, how supportive is it of the case?
I think, when you're quantifying necessity, again, it's all additive. So it adds to the evidence that supports Evergy's application. It's a previous commission order that spoke to the necessity. I would say it's probably strong support.
Let me continue on page 7 of your testimony. Have a question about. Do you understand that the Kansas statute requires that the project, in this case, the Buffalo Flats project, is required to be considered separately by the commission as to whether or not it is necessary?
We did a separate analysis of necessity, yes.
Would you repeat your answer?
Yes, we did a necessity analysis within this docket.
Well, let me ask you a further question then. I thought your earlier testimony was that the only consideration by SPP was for the Branson 345 kV overlay project. Is that correct?
So, could you rephrase that question, please?
Certainly. As I understand your prior testimony, you indicated, as I understood it in any event, that the only examination done by the Southwest Power Pool Southwest Power Pool was not separately for the project, but was as a part of the Branson 345 kV overlay project. Is that a correct statement of your earlier testimony?
Yes, when the SPP evaluated their reliability and associated cost benefits, they considered the entirety of the project. The Buffalo Flats line can't really be considered in isolation because it would end at the Oklahoma border and power wouldn't be able to flow through it. So by necessity, they had to consider all the components.
Do you understand our statute is requiring you to speak to the necessity of the Buffalo Flats project and not the Branson 345 kV overlay project?
I am, so it is tied into the rest of the project, which provides benefit. If it was just routed to the Oklahoma border and we only considered that segment, power wouldn't be able to flow over it.
My question is, do you understand that the statute in Kansas, or is it your understanding more correctly? Is it your understanding that statute in Kansas requires you to consider the benefit of the project, that being the Buffalo Flats project, and not the benefit of the Branson 345 kV overlay project?
We considered the benefits of the Buffalo Flats line as it exists within the Branson 345 kV project.
The Branson 345 overlay project, as I understand, looking at your testimony, is a 316-mile project. Is that how you recall it to be?
I don't know that I stated the length, but that seems right.
And what's the length of the Buffalo Flats project?
I think as proposed in the application, it was 133 feet. Or miles, excuse me, geez.
Okay. Now, on page 9 of your testimony, Mr. Owens, you indicate that the connection point in Kansas is a major wind interconnection point. Why is that important?
SPP stated that in the ITP, and I thought it was important to put directly in my testimony so people could understand. That was some of the reasoning that the SPP stated within their ITP that that location was selected.
Would your statement indicate that? Well, I don't know. Would your statement indicate that a material reason for making that the interconnection point is that there was an intent to move wind from that point from its interconnection point eastward?
I'm not quite sure what you mean by material, but I would say the primary purpose of the project was to improve the reliability of the region, including transmission lines in southeast Kansas. And an additional benefit is that Kansans can export wind power, a resource that we have within the state, within the SPP region.
Would you agree with me that the wind development is owned by private individuals and for the most part, not by electric utilities?
I would agree that for the most part, it's owned by developers.
Okay. Can you give me a reason why we would pay, retail ratepayers would pay for improved market access for private wind developers?
I think if that was the only reason for this line, then it might exist as a market-based line like Grain Belt, but the reason that it's being regionally allocated as such is because it's a reliability line.
Let me ask you this. Do you think the wind developers should pay any part of their transportation from the interconnection point to markets in Missouri?
I don't really have an opinion on that.
Well, let me ask you that. Well, may I ask the reporter to read back that question?
Sure. Question, let me ask you this. Do you think the wind developers should pay any part of their transportation from the interconnection point to markets in Missouri?
And what was his answer, please?
The answer was, I don't really have an opinion on that.
Okay, thank you. May I continue on now? Okay. Do you think it's important, Mr. Owens, for costs and benefits to be aligned?
Yes, generally speaking, I think it's important for cost and benefits to be aligned.
Would you agree that if wind developers receive the benefit of expanded market, that they should pay a part of the transportation to that expanded market?
I think that it would highly depend on the scenario. If that was the only thing that the only factor considered was gaining access to a market, then perhaps, unless that market itself wanted to pay for it, such as the Grain Belt line.
Okay. Let me direct your attention to the question of importing and exporting power. Do you recall that part of the examination that I conducted with the witness from Southwest Power Pool?
Can you be a little more specific, please?
Do you recall the portion of my examination where I presented an exhibit to the witness from Southwest Power Pool, where we discussed the amount of time that Kansas imported power and the amount of time that Kansas exported power?
Yes, I remember.
And do you recall that Kansas exported power 346 days per year?
Yes, I do.
And is it your opinion that the bidirectional flow of electric power from the Delaware station marginally or materially or in any fashion improves reliability in Kansas?
Yes, I think that the ability to move that power to regions where it's needed improves reliability in Kansas.
And if we're exporting 346 days per year, and we now have this right of importing power, how often do you think we'll use it?
I don't know.
Give me just a second. I want to go to the testimony. Mr. Owens, do you recall if Evergy in its application or any of the testimony filed at the time they filed their application in support thereof mentioned the Flint Hills even one time?
I don't recall whether they mentioned it in their application.
Would you be surprised if I told you they didn't mention it?
No.
Why wouldn't you be surprised if that's an important part of this case?
Because I don't recall reading it.
Now, you deal with the Flint Hills in your testimony, do you not?
Yes.
And you spend a brief period, I want to say it's on page 40. I want to get exactly. It's page 41, Mr. Owens.
In a moment. Okay.
Okay. Now, do you have any concern that Evergy would build through the Flint Hills?
I think there are concerns about the ecosystem and they need to restore it. Yes.
If I were to tell you that if the disruption was so material that it would be unlikely or even impossible to restore parts of the Flint Hills, would your opinion be that there should be an alternate route looked at?
I looked at this issue from two perspectives. The first one was the start and stop point of the line. After I concluded that that was reasonable, then I didn't see a way to get around the Flint Hills. There's only a 20-mile corridor between the Flint Hills and Nebraska. I also considered this from a broader, more holistic perspective as can the state of Kansas stop building transmission lines in the Flint Hills altogether? And I think that the way our state is configured and the electric system is configured, we have generators in western Kansas and load in eastern Kansas. So I made the conclusion that in terms of policy, we can't stop building transmission in the Flint Hills due to the nature of the grid and the impacts it would have on Kansas, our economy, and the reliability of our electric system. So I kind of came at it from that perspective. I looked at the existing line, I looked at the broader impacts, and then I looked at the net impacts of permanent grassland destruction in later testimony, which was 0.2 acres, and made the conclusion that while impacting the Flint Hills is unfortunate, we need, first-in-class restoration, and we also need transmission through the Flint Hills to serve Kansas.
Let me back up and go at this a little bit in several different ways if I could. Do you remember the part about the cross timbers portion of the Flint Hills ecosystem?
Are those the trees that are from the 1700s or something?
Yes, sir.
Yes.
And do you agree with me, if those trees are removed, you can't put them back, right? They're gone. That part of the Flint Hills is historic. Do you agree with that?
I agree that you can't replant a tree after you cut it down.
And you can't and you talk about restoration, I should say, you really don't get as to how long it would take to do restoration. In this case, it would take 300 years, right, to replace those trees?
You wanted a 300-year-old tree, yes. And Evergy won't allow trees in their right-of-way. So, I kind of looked at the restoration requirements in the law. There's a statement that the transmission owner needs to restore the property to original conditions. I think, it's somewhat obvious that certain things like tree removal won't be put back into place.
Before I go any further, let me ask you, you used throughout your testimony like a desktop review. What does that mean, and how much confidence do you have in that?
I have, I would say, significant confidence at this point. We had Evergy produce GIS data that marked all of the houses and constraints, and then we could look at those on aerial imagery and try to cite the line. It's similar to the way that routing studies are complete.
Were you concluded, Mr. Owens? Okay. Evergy didn't produce for you, did they, all the oil and gas leases in the study area?
Not the leases.
Excuse me, I couldn't hear your answer, sir.
No, not the leases.
Okay. And you couldn't conduct even a desktop review, could you, of the infrastructure associated with the leases in the 5 counties that we're talking about?
We did not conduct a desktop review within the 4 counties.
I said 5 counties. Did you mean to say 4 or 5?
Yeah, I believe it's 4 counties.
Okay.
Sedgwick, Cowley, Chautauqua, and Sumner.
Okay. Do you place a high value on the maintenance of the Flint Hills ecosystem, which includes the Cross Timbers area?
I don't quite know what the maintenance of the ecosystem is.
Well, let me rephrase it differently. Do you place a high value on maintaining the Flint Hills region in its current status?
I think I'm going to object to this question that the witness has already answered in response to an earlier question that was essentially exactly the same.
Does there occur any response?
It's a different question. I rephrased it so that it would be more clear and be different.
I recall a similar question earlier, but frankly, I can't tell you whether it's exactly the same or not. So I think I'll overrule the objection and I'll let the witness answer as best he can.
So this is somewhat hypothetical and limited, but in the context of a routing study, I value all impacts, and I think they should be compared and balanced in order to get a reasonable route. I don't think we look at one single impact in isolation. So I think that it's important to perform a balanced study and consider a variety of impacts when determining the reasonableness of a transmission line.
Does the fact that, assume these facts, if you would please, assuming that that only 4% of the original tallgrass prairie remains, and that 2/3 of that is in Kansas, do you believe that there should be special attention paid to the Flint Hills in considering a route and citing a route?
Well, if Evergy was going to consider impacts to the Flint Hills, I suspect they would add a criteria that was length within the Flint Hills, and that criteria would be evaluated. I believe Evergy witness Lovelace said this was the shortest route in the Flint Hills. The way the routing study works is they compare routes to one another, so this would have been the most favorable route in terms of impacts to the Flint Hills because it minimized the length. In terms of some sort of broader policy as a state employee, I'm not going to opine on that.
You're refusing to answer that question, or your opinion?
I believe I answered the question, but if I missed out on a policy portion of it, like if you were asking as a point of policy, should the state of Kansas do something, I would say that I'm not going to provide opinions about policy. You know, we have internal processes to do that sort of thing, and making a decision right now would be inappropriate.
May I ask the chair to rule on whether or not you should answer the question?
Give me your specific question again, and then explain to me which part you do not believe he answered.
Were you speaking to me or the witness?
Yes, Mr. Zakura.
Okay. I asked the witness if he, as the chief engineer, if it's his opinion that the state of Kansas should give special consideration to the Flint Hills when siting an electric transmission line. I asked for his opinion.
Ms. Hain, any response?
My witness can speak from his opinion, but he's not qualified to state a policy on behalf of the state of Kansas.
I did not ask that.
So my understanding of Mr. Owings' answer was that he gave his opinion, but I'm not sure what he can provide beyond that. I don't think I'm going to direct him to give any particular answer, but if you want to ask it more specifically to him, if there's some aspect you don't feel that he answered.
May I respond to that, please? I asked his opinion, and he said I refuse to give my opinion.
If
you
the
ask
witness
the question again, please, or sorry.
Let's try it again. Why don't you ask the question of Mr. Owings, and we'll see what his response is. But I'm not going to direct him to offer an opinion.
Is it your opinion, Mr. Owings, that it would be appropriate? Is it your opinion, Mr. Owings, that it would be appropriate for the state of Kansas to give special consideration to the Flint Hills when considering the issue of siting an electric transmission line?
I would say that, you know, that was not in the line siting guidance document. And, you know, as a state employee, I follow state policy, and I don't have an opinion specifically, but I did give the hypothetical. If we were to consider impacts to the Flint Hills, I would suggest that it's done on a length basis. So I guess I'm not completely opining to the importance of it. I would say that it's, you know, in the context of routing studies, it is a reasonable thing to consider impacts to the Flint Hills. I think that would be a reasonable item for a utility to consider when they're performing a routing study. And I definitely wouldn't object to the reasonableness of length within the Flint Hills, albeit that if we did it in this docket, you know, hypothetically, that the preferred route would have been high scoring.
Do you recall Mr. Lovelace's testimony that the length of the route to the Flint Hills is 35 miles?
I believe that's correct, subject to check.
Mr. Owens, Chairman French, thank you. I have nothing further.
All right, we will move to Mr. Buck. Do you have any questions of this witness?
I know everyone's going to be sad, but I have no questions for Mr. Hall.
I'm really disappointed, but
Thank you.
All right, thank you, Mr. Buck. Okay, we will move back to commissioner questions at this time. Did anything in that examination prompt any additional questions from the commissioners? Commissioner Keen, I'll just call on you first. Do you have anything additional?
Yes, I do. Thank you. I'll take the video down. As the court reporter, can you hear me?
Right now I can, yes, sir.
Okay. Well, let's hope it stays.
Definitely.
A general question, Paul, and then I want to do some backfilling on questions that you've been asked by others. If Evergy hasn't thoroughly considered and evaluated all viable options and alternatives to their preferred route, how could it be concluded that the preferred route is reasonable?
I would say that the standard for consideration in this docket is that Evergy propose a reasonable route. I don't know that considering all viable alternatives is required.
So if they even selected this route by sticking pins on a map, that could conceivably be a reasonable process for selecting a route, correct?
I suspect if it was just random, we would conclude it wasn't reasonable.
I want to really turn back to one of the more important questions that's been asked today. And it was asked by Commissioner Keither. And I thank her for asking the question. I want to pursue that line of questioning myself.
Sir, I lost you.
Casey, can you hear me?
I lost you after you said one of the more important questions that's been asked today by Commissioner Keither, and then it broke up.
Okay. And that dealt with the subject of environmental stewardship. Can you hear me now?
Yes, sir.
Are you hearing me now?
Yes,
okay.
Thank you.
Thank you for noting that. Appreciate it. I'm not sure that I had an answer from you to that question, Paul. In your opinion, is the Corporation Commission, do we have a responsibility to be environmental stewards?
I think that in the context of electric transmission line sightings, we have a couple considerations. The first being restoration, which is specifically stated in the statute. And then the second is reasonableness of the location. I think that, you know, looking back at the general investigation, honestly, staff focused on social concerns and the utilities brought forward. The utilities were the ones who were also concerned with the environment. So I think it's definitely reasonable for them to consider environmental concerns within their routing study. So yes, I think we have, you know, the reasonableness of the route reflects on consideration of some environmental criteria.
The reasonableness of the route reflects upon the adequacy of that review, doesn't it?
I think if they completely neglected environmental considerations, the commission could, you know, take that into consideration when making their determination.
Certainly within the conservation division, I'll come back to the point of this line very quickly here. The commission has an important environmental stewardship responsibilities. Protection of correlative rights, and that's the rights of offsetting oil and gas lease operators and owners. The protection of the state's freshwater resources, and the prevention of waste. Each of these charges are deeply rooted in environmental stewardship. When we flip to the utilities division, back to the discussion that you had about sufficient and efficient service at reasonable rates. How can we get to this result without, in significant part, being environmental stewards?
I don't know how we can get to that result without, so the result of environmental stewardship. I believe that, you know, in the context of the line sighting, considerations of environmental impacts relate to the routing study.
Well, I think environmental stewardship, pardon me, is implicit in line sighting issues, because line sightings are replete with environmental consequences. Isn't that correct?
I think that, you know, line sighting relates to the reasonableness of the location, which can include impacts to environmental resources. And it's my understanding we've decided in Kansas to take a balanced approach where we consider a wide variety of impacts ranging from, you know, farming and agricultural to residential proximity to environmental, and we try to balance those impacts to select a reasonable route.
Is it fair to say that a major charge that the commission has in evaluating applications for line sightings is to perform those balancing functions to which you allude, and determine from among those choices, based upon the evidence in the record, whether there is reason to believe that the that the charge in this particular case, which is in order to grant line sighting, that there be basically both its necessity demonstrated and its reasonableness demonstrated. Isn't that correct?
Yes, I think that, you know, performing an analysis of a utilities routing study to ensure that they've considered those factors is a part of the study, you know, of staff's study and analysis that should be complete, and I did complete that review.
All right. there was a lot of due consideration within the questions, and I think your responses to the issue of restoration and remediation. You recall those discussions?
Yes, I do.
Are all transmission line location construction disruptions and operational disruptions capable of being restored or remediated?
I don't think I would go so far to say all. For example, the cutting down trees, vegetation removal can't be restored. And then I think a lot of landowners point out that, there's still a visual impact, which the only way to avoid that is to bury lines, and it's 5 to 10 times as expensive. And I guess, the visual impact, just philosophically, how staff use that is to minimize residential impacts. And by keeping the line away from homes, you've decreased the visual impact of it. So to go back to your question, I think that restoration relates to disturbed areas outside of the pole, and it doesn't relate to trees and other things which would potentially compromise the reliability of the electric system.
Well, the inability to restore and remediate deforested areas, I think, is a big deal. And you alluded to the views and the vistas that would be destroyed as well. There's really no way to remediate that, is there?
No, and that's consistent no matter where you build transmission lines.
Do you believe that has value, the views and the vistas?
Yes, I believe that all Kansans who live in rural areas value their views, whether they're in western Kansas or the Flint Hills or northeast Kansas. And I think we should take those values into consideration. I think the best way to mitigate visual impacts is to avoid homes, so fewer people have to look at them on a regular basis.
Well, I would argue that, at least as I understand agricultural and ranching activities, it's not confined to the home, it's out and about. and so I would argue that maybe it's the vistas and views aspect of this is a little bit broader than just the view from the front window. Let me ask you this. How do you restore and remediate the permanent disruption or destruction of native soils and grasses?
I think that Evergy has, provided evidence of construction of numerous transmission lines, so they have experience restoring these sensitive ecosystems. And I took that a step further by requesting they require a professional to provide best management practices on restoration, and perhaps we can even require commission involvement in the procurement of those services or in some sort of fashion to ensure that Evergy is doing all they can do to restore the Flint Hills to their original conditions.
I'm not talking about the Flint Hills. I'm not restricting this to that 35-mile area at all. I think it's there's a lot of this that transcends a lot of this 133 miles that are in Kansas, don't you?
Yes, and we speak a lot about compaction, especially in cultivated fields. Compaction is very impactful, and I think staff witness Hanos talks about compaction a little, and that was part of the impetus of having them create those agriculture mitigation protocols. I think that restoration of all property is important. We talked about this previously about the attestation of the utility that they've completed the restoration. I think there could be benefit for them to pointing out any disputed areas where the landowner is disputing that they've completed the restoration of their property. You could, have Evergy potentially send that attestation to property owners, and they would get a chance to respond to the commission. And in that case, we could look at the restoration practices within the complaint system at the commission to evaluate the adequacy.
You recall some of the landowner testimony that we heard on Thursday during the evidentiary hearing?
Yes, sir.
You recall some of that testimony to the effect that disruption of soils and native grasses in many of these areas render them virtually incapable of being restored? Do you recall that?
I recall individuals stating that, yes.
You question the truthfulness of that statement?
The truthfulness of what?
Of that statement.
Thank you.
I don't have the experience to know whether the Flint Hills can be restored fully or not. However, I looked at this in totality from could we avoid building transmission lines in the Flint Hills? And I concluded that as a state, due to the nature of our generation being in western Kansas, a lot of it, and load in eastern Kansas, that there's inevitably going to be some construction in the Flint Hills. I think we should require, first-in-class restoration, but we have to balance, in my opinion, we have to balance the good of the public, of all people of Kansas, with potential impacts to areas of the state. I know that we focused a lot on the Flint Hills, but if you drive through western Kansas, they've had impacts as well with numerous transmission lines and wind fields, and I think I would take it serious in all areas.
Well, I'll grant you that. I believe that the governor, through her moratorium, indicated that she thinks that there's a very necessity to protect the Flint Hills. Wouldn't you agree?
Yes, she indicated the governors and past governors had a moratorium on wind development infrastructure.
Talk about the wetlands impact. We know that there are wetland areas that are within the path of this proposed line. How do you store those areas?
I believe with wetlands, there's different requirements of the Army Corps of Engineers, and if you disturb those areas, sometimes you have to buy wetland credits, but I think you can also, go over the top of them due to the nature of transmission lines. So it may be within the right of way, but you place poles on either side of it and go over the top of it. I've done linear infrastructure projects that were partially in wetlands, and there's often seeding requirements and special restoration requirements that the Army Corps of Engineers has under their nationwide permits. Evergy would be obligated to acquire those permits and follow those requirements. Evergy is obligated to anytime they build something.
How are historic preservation impacts remediated and restored?
I am not incredibly familiar with the historic, I think it's the Historic Preservation Act. I would suspect, if Evergy's within a certain distance of a historical site, whether it be a bridge or, home, they would be required to get a permit through the State Historic Preservation Office, and that permit would stipulate on whether they needed to mitigate it or move the line. In terms of historic preservation, I guess I wouldn't guess what they're going to require in terms of mitigation.
In terms of oil and gas activities, how do you restore or remediate the deprivation of correlative rights, or the deprivation or diminution or impairment of the implied oil and gas lease rights and covenants to develop, especially when you have an intrusive line running through the property where the wells, where the lease basically is very densely populated with wells?
I would go back to the argument that utilities have an intrinsic motivation not to damage those interests because they could be held financially liable for them.
Well, I think there's some truth to that, but wouldn't, I mean, just the algebra prevention, as they say, is worth a pound of cure. Algebra prevention here is to not run this line through these sensitive areas that have all of these different impacts. It would strike me that's not the course that the applicant Evergy nor the staff have taken. But I think that we need to take a close look at all the trade-offs that are involved. That's something that is way beyond just the eye shade and the pen and the compass, to take into consideration the impact that this proposed line is going to have on some of these issues that are, once it's despoiled, it's done, it's over. And so in any event, I believe that's the last of my questions at this point. Thank you, Chair French. Thank you, Paul.
All right, we will now turn to Commissioner Keither for any follow-on questions for Mr. Owings.
I don't have any follow-on questions. Thank you.
All right, thank you, Commissioner. And I also do not have any additional questions for you, Mr. Owings, so we will turn back to your counsel. Ms. Hain, do you have any redirect?
Dear French, I don't have any specific redirect questions actually for witness Paul Owings. I do have kind of an unconventional offer to make to the commission at this point, though, if they're willing to hear that offer.
Certainly.
This is not a request, it's just an offer on behalf of staff. But at several points throughout this hearing, even last week and today, the Director of Utilities, Justin Grady, has been mentioned in reference to his review of the direct testimony that was submitted in this docket, as well as in reference to his participation on SPP committees. And Justin Grady has been present at the hearing throughout the hearing. He is actually available if the commissioners or any of the parties would be interested in asking him any questions.
Okay, thank you, Ms. Hain. Let me first dismiss Mr. Owings. Paul, thank you so much for your testimony today. You may virtually step down.
Thank you.
And now we will take up this offer. As I understand it, because Mr. Grady and his participation in this case was referenced, staff is just offering him if the commissioners or any parties have questions. So I guess first, let me ask the commissioners first if they have anything they would like to take up with Mr. Grady.
No, Chairman.
Chair French.
Yes.
Yeah. I'd be pleased to have the opportunity to ask questions of Justin.
Okay. Well, since we've at least got one commissioner on record that would like to question Mr. Grady, I guess we'll go ahead and have staff call him up. And then I know Mr. Zakura had questions that I believe Mr. Owings deferred or at least referenced Mr. Grady on. So we will of course give an opportunity for the parties if they think they need to ask a question of Mr. Grady.
May I be heard?
Yes, Mr. Zakura.
I, of course, am not going to object to commissioner questions, but I do object to Mr. Grady going onto the stand for parties' questions. There's no pre-filed testimony. He was mentioned in reference. He is not. I would strongly object to that.
Okay. So what I will direct staff to do is to lay some foundation for what Mr. Grady's position is at the KCC, what his responsibilities were with reference to this docket, and then for anybody wishing to ask questions, this is not an opportunity just to lay additional direct testimony. This is an opportunity to get detail that could not be offered in staff's other responses at points where they may have referred to working with Mr. Grady. So with that, I will allow, go ahead, was there a response there?
May I please?
Yes.
There's every opportunity in the world for Mr. Grady to file pre-filed testimony. I mean, this is just like someone, maybe I could go on the stand and provide testimony. This is highly unusual and we would continue to object. Of course, we're not going to object to the commissioner's testimony. Commissioners have a right to get whatever fact finding they deem is appropriate for them to make a decision. But we find it highly objectionable for Mr. Grady to come on at this point, at this time, when he had 6 months to file testimony or originally to testify in the case. That's why Mr. Owens is in the case. He's the representative of the staff. Thank you.
Okay, I think that was the same thing you said before. So we will we'll have staff go ahead and call their witness and lay some foundation. Again, no additional direct testimony, just an opportunity for commissioner questions, and if the parties wish to cross-examine him, they may.
Thank you, Chair French. Staff calls Justin Grady to the stand.
Mr. Grady, actually, I'll go ahead and just swear you in. Are you ready?
Yes, I am, Chair French.
I can't see you, but please raise your right hand. Do you swear or affirm? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right. Please proceed, Ms. Hain.
Mr. Grady, will you please state your full name for the record?
Yes, good afternoon. My name is Justin Grady.
And who is your employer and what is your title?
I am employed by the Kansas Corporation Commission. I'm the director of the Utilities Division.
Are you the same Mr. Grady who reviewed the direct testimony submitted by staff witnesses Leo Janos, Matthew Galino, and Paul Owings in this matter?
I am.
With that, I tender the witness for commissioner questions.
Okay. Commissioner Keene, I think you indicated you have questions for Mr. Grady.
And Commissioner Keene, you did cut out somewhat during your last segment of questioning, so.
Can you hear me now?
You're staticky, yes.
I clear my throat. Can you hear me now?
I can hear you this moment.
Okay.
Commissioner Keene, I'll mention it does get better when you shut your video off. It's a bandwidth issue.
Done. Better for everybody else too. All right, very good. Can you hear me, Justin?
Loud and clear, sir.
Court reporter, can you hear me?
At this moment, yes, sir.
When you can't, you tell me.
I will.
If you can't. If you can't. All right.
I will.
Justin, are you aware of notices to construct that have been granted by the Southwest Power Pool that involve lines in Osage County, Oklahoma?
Commissioner, I am not aware of any notices to construct that have been issued by the Southwest Power Pool that traverse Osage County in Oklahoma. I'm certainly aware that there are notices to construct that have been issued by the Southwest Power Pool in the state of Oklahoma, but I'm just not personally aware that any of those NTCs have specifically impacted infrastructure in Osage County.
Okay, that's fair enough. I've had staff perform some research on that for me. They do exist, but I'm not going to deliver. I'm not going to dwell on that. Are you aware of any notice to construct within the Southwest Power Pool's domain that have resulted in Public Utility Commission rejection of portions of the lines that have been proposed by the SPP?
Am I aware of any instance in which a line siding proceeding has been denied after the SPP issued a notice to construct? Is it, or just a portion of the line? Is that the question?
That is the question.
You know, I'm not aware. As I sit here today, I cannot recall an instance in which a line siding proceeding that I'm aware of, in which a line siding proceeding, in which a commission within the Southwest Power Pool has denied a transmission line siding permit to be built.
Well, again, staff research has indicated that there is a 2018 docket before the Oklahoma Corporation Commission that involved a portion of the line going into Texas, and evidently the Texas PUC rejected the portion of the line in Texas. So I think there is some evidence that states do on occasion reject proposed sidings. In this instance, if for any variety of reasons that may have been discussed during the course of the last 3 days in this evidentiary testimony, the commission should decide to either condition or deny this application for line siding. In either case, is it likely that the sun's going to come up from the east the next day? Let me ask that question more seriously. If we effectively were to ask,
I'm
or
sorry,
to say
sir.
basically no.
Sir?
Yeah.
After you started to ask after you said you wanted to ask your question more seriously, it just cut out.
Probably for the better. Can you hear me now?
Yes, right at this moment I can, but it slows down and it drags and you are very hard to hear. I thought Mr. French had said earlier if it continued, maybe he could call in.
If it continues, I'm going to change locations and see if that improves my plight.
It is continuing. It has continued. I assume it will continue.
Why don't we go ahead? We've been going for quite a while now. This is Chair French. Why don't we take a break until 3:20? And Commissioner Keen, if you want to try another location, does that give you enough time to try another location?
How much time was it?
Well, 6 minutes till 3:20. Would you prefer we could go till 3:25?
No, that's fine. That'll do it.
Okay. Let's take a break until 3:20, and then we will recommence the questioning. So we are off the record, we are in recess, and we will reconvene at 3:20. All right, this is Chair French. Let's take a moment to see if we've got everybody back. Commissioner Keen, are you back with us?
I'm relocated. Can you hear me?
I can hear you. I will say the little indicator next to your name is still red, so it may not be better than before, but let's give it a try. And if it's problematic, we'll have you call in on the Zoom number.
And Chair French, you're sounding a bit quiet and muffled now.
Yeah, that's what I was gonna say too.
All right, how's that sound?
That's about the same.
Kristen, how is my communication with you?
Yeah, you sound great. You sound very clear.
I get 3 bars here now. Can you hear me, Justin?
Yes, loud and clear.
Okay, can everybody hear me?
No, you're really muffled, Chair French.
I'm on. Well, let me just take my earbuds out. Maybe I'm having an issue. All right, I'm just on the laptop now. How is that?
That's better.
Sorry, I had my microphone double muted. Okay, can you hear me now?
Yes.
Yes.
Okay, try it again.
Yes,
Still
we can
good.
hear you.
Can you hear me,
us?
Tracy?
Are you hearing us okay, Chair?
Yes, I hear you. Can you hear me?
Yes.
Oh, okay, great.
Yeah, sounds great. Thank you.
All right. Anybody not ready to go? Hearing, we will proceed. We are back on the record in this evidentiary hearing, and we are resuming Commissioner Keen's questioning of staff witness Justin Grady. Commissioner Keen, please proceed.
I'll first ask Leanne, can you hear me now?
Yes, sir. I can always hear you when you say, "Can you hear me now?" But sometimes when you're asking questions for the record, I cannot. So we'll hope your new location fixes that.
Let's hope that. Does it seem clear to you now?
Yes, sir. We're not on the record, so it seems clear. Yes.
Go back on the record and throw caution to the wind. I don't know.
Okay.
Chair French, it's up to you. Okay. Justin, let me try to resume asking you the question I was asking you. Can you hear me?
Yep, loud and clear.
All right. If the commission, I'm going to ask you a series of hypotheticals. If the commission were to grant the application subject to the satisfactory resolution of several conditions to the grant of the application, is there precedent for that?
I think there is. I mean, there's certainly been several conditional transmission line siding certificates issued in the past. I think, the question would become how extensive are the conditions and whether or not there has actually been precedent for that or not will probably be a fact-specific inquiry, but it's clear that statute allows the commission to condition the line siding order in the fashion that it deems best serves the general public.
I'm talking about the potential for conditions for which there is an affirmative obligation to provide answers satisfactory to the commission in order to remove any conditional grant of authority to construct.
I don't know if a commission order, I don't know if there's been a previous instance of a commission order in a transmission line siting docket like that. But I definitely think that is a potential in this case. And I would say that, you know, on behalf of staff, that would be much preferred as far as we're concerned, as opposed to an outright denial or a finding that the commission found that the route was unreasonable.
Yes, in the instance of the hypothetical I just posed to you, I'm far less concerned about precedent than I am about our doing the right things. So I understood from the prelude that we had from Ms. Hain that you've been tuned in to all of these proceedings so far during this, now close to the end of the third day. Is that correct?
That's correct. On Wednesday, I missed the hearing until around 2 p.m. But thankfully, since it's on YouTube, I was able to go back that evening and listen. And I finished up in all of Tuesday's evidentiary hearing prior to Wednesday morning beginning. I'm sorry, all of Wednesday's evidentiary hearing prior to Thursday morning beginning.
How is it possible for the commission to reconcile restoration activities that involve almost the impossibility of restoration, where there is basically, once the damage is done, the harm is permanent, and at least within all lives and being here, forever irreconcilable? How do we deal with those?
That's a really good question. I would say that it's an unfortunate reality of a lot of forms of energy infrastructure that I just think the reality is that there is no perfect answer in terms of siting energy infrastructure, no matter where or what kind it is, where you put it physically, there's going to be an impact on the land. And I certainly don't say that to suggest that, that we shouldn't consider what that impact is going to be, or that, that we should just flippantly evaluate those types of environmental concerns. I just think the reality is, no matter where we put a transmission line in the state of Kansas, there is going to be some harm. With the discussion earlier about century trees and ancient trees, I'm a tree enthusiast. A lot of people that know me personally know that. I think it's going to be a significant impact and potentially, devastating in terms of those specific trees. But we're not going to take out all of those trees. I mean, Evergy, they build a transmission line through there. They're not going to allow those trees to be in the easement itself. But I guess the way I look at that is the commission has to evaluate the importance of those trees and how many trees will be lost relative to that entire cross timber section, and relative to the idea of the benefit of beneficial infrastructure for our state, for reliable electricity, affordable electricity, and the growth of our state moving forward. I would say with regard to remediation efforts, on staff, I personally was proud of. I thought that Mr. Owings' recommendation to hire an expert that is qualified in Flint Hills restoration practices, I thought that was a very thoughtful condition, and perhaps it could be improved. You know, perhaps the commission should select or has veto authority over that contractor that is selected. But, you know, the reality is what we've heard through this proceeding is that Evergy has over 1,000 miles of transmission lines in the Flint Hills. They have over 400 miles of transmission lines that are above, you know, they're 345 or larger in the Flint Hills. So you know, Paul and I, Mr. Owings and I are not Flint Hills grassland restoration experts. But when you have a company that has that kind of experience building transmission in the Flint Hills, I guess we were hopeful that if they hire a restoration expert in the area of, you know, reseeding native grasses, there's, you know, we could look at and I think we could evaluate the reasonableness of the restoration practices of some of these transmission lines that have been in the Flint Hills for 30 years. And we could go back and look at those easements and evaluate the impact that that's had on the area. It is undeniable that there will be certain impacts on the land where this transmission line is that cannot be remediated. But in the areas where remediation is an option, I thought that we had addressed that to the best of our ability. But if the commission has other better ideas, we're certainly open to that.
Well, my concerns include, but go far beyond the Flint Hills. I'm more concerned about the longer expanse of the line, whether it's from west of Elgin all the way through Chautauqua, Cowley, Sumner, and Sedgwick counties. And there are some serious impacts that this line is going to cause if it's approved that I believe have been inadequately researched. They've been inadequately considered. And notwithstanding however many permutations and combinations of lines Evergy may have gone through in the process of identifying this line from among 10 or more or 5 or whatever it was that they ultimately used as a method to cut down to this particular route. This route, I think the record indicates that this route is going to impact a fair number of it's going to create a fair number of impacts that I just don't believe have been adequately considered in picking the route. Matters that go far beyond the purview of any concern that SPP has. They're concerned about other matters that we are. I think we're concerned about more matters than they are. And I think being concerned about environmental stewardship and concerned about the welfare of Kansas residents that are directly affected by this, as well as those indirectly affected by this, is part of the purview of our concern, part of the balancing proposition we have to go through. In the event the commission did deny this application, what's the next step?
Well, that's a good question as well. I don't want to do your question a disservice by suggesting that I would be able to answer that question comprehensively on the fly. I think that's a really good question for briefing, because I would need to consult the open access transmission tariff of SPP. I mean, there's a couple of things I can tell you off the top of my head, but it's not going to be a comprehensive response. So I just wanted to preface my response with that. I believe if Evergy is not able to complete the requirements for the notice to construct, that they will inform SPP of that effect, and then the notice to construct will be reevaluated If the project is going to be delayed by a certain amount of time, if there's going to be a cost increase over a certain amount, all of those potential outcomes would require Evergy to notify the Southwest Power Pool that it was not able to complete the notice to construct. And I think at that point, the SPP board would go back to the drawing board, so to speak, and reevaluate. But I think what the hope is that there would be conditions. For instance, if the commission found that the line siting application was deficient in some fashion, that the commission would condition the line or condition the permit to the satisfactory resolution of those issues. You know, the commission, I'm just brainstorming here, this is probably going to be dangerous, but the commission could condition the permit to say that we want Evergy to validate that in fact no active above ground oil and gas infrastructure is going to be taken out of production as a result of the permitting of this line. You know, the commission could condition the permit to say, you know, given the current uncertainties about oil and gas leases that go through the proposed route, we are requiring that Evergy file a compliance filing detailing specifically how they were able to microsite this transmission line to mitigate any potential impact on, you know, current or future oil and gas operations within the routing network. I mean, I think that the sky's the limit in terms of what the conditions could potentially be that the commission could require if that's what was necessary. And, you know, perhaps the result of that would be a delay in the construction of the transmission line, but it's possible that it would not have to result in the delay of the transmission line, depending on what the condition was.
All right. So it's possible then you think to fashion conditions that could certainly buy the commission additional time to have through the compliance with those conditions, hypothetically, either Evergy or its third-party contractors to provide answers to questions that the commission has about in more detail about the impact we may be concerned with.
Yes, I do. You know, as I've sat through this proceeding and listened to a lot of the concerns that have been addressed by some of the landowner interveners as well as commissioner questions, that I've personally thought that was sort of a missing solution that hasn't been discussed much in terms of, like, for instance, just speaking specifically about the oil and gas lease activity and the question of, you know, should all of that detailed survey work, or should all of the identification of the oil and gas operators and the leases, should that have been done as part of a routing discussion, or should it have been done after the commission approval? I mean, I understand there's significant diversity of opinion on that specific issue, but as I was thinking through that, I think creativity in terms of the commission could condition the approval of this line to specifically address whatever the concerns are with regard to oil and gas conservation. I mean, you know, Commissioner, when we have discussed this issue, we're not convinced that the transmission line is going to significantly impact oil and gas exploration and production along the route of the line. And that's because our position is that if you microsite this transmission line appropriately and you go along parcel boundaries and you go along the edges of oil and gas leases. I mean, our understanding is that there are certain setback requirements and there are certain spacing requirements for the edge of a lease anyway. And so what, you know, we're, and I don't want to say hopeful, but our position has been that they are going to microsite around existing active oil and gas leases. And they will work with the operators of these leases in order to not significantly impact future oil and gas operations. But, you know, the commission doesn't just have to take Evergy's word for that or staff's word for that. I think the commission could fashion a condition in this permit that says this is our requirement. And if you, you know, and the permit is being conditionally approved. And ultimately, there's going to have to be a compliance filing that is filed that shows that you did fulfill these requirements and these conditions. And ultimately, I mean, Evergy is a public utility. If they don't do it the way that we want them to, then the commission can order them to change it and remediate as necessary, or microsite in a better fashion, or even ultimately move the route of the line if that's what's necessary, if micrositing is determined to not be possible. So that's the way I've been thinking through conditions and, you know, potential compliance issues. Because I know that Evergy and staff, and the Southwest Power Pool for that matter, I'm nearly certain that those three parties would prefer to have as much direction as possible and compliance directives that the parties can that provide a potential path for success is a much better outcome than just an outright denial of the application.
And I appreciate the hues of gray that you tried to address in that response. I have some serious concerns that involve permanent damage for which there is no reclamation, whether it involves farm and ranch uses, whether it involves wetland issues, whether it involves deforestation issues. These seem to present themselves in abundance in South Central and Southeast Kansas, because that's where most of these issues arise within the context of the state taken as a whole. So we have all of these things at work. Matters for which, once the construction's been undertaken, there really is no answer. There's no going back. And I have some real concerns about how that impacts this particular area because of the diversity of the impacts that there are, independently of the oil and gas issue that you just addressed. I have some real concerns here. I think there are some intangibles here that are, I think, not really getting maybe the just consideration they deserve. Even when I look at some of the scoring that goes into some of these determination of one line route versus another. But that's just my personal concern. But there are some issues for which I don't think anything, any conditions can remedy. That's a real big concern.
No, I appreciate that. I understand. Like, the only thing I think I can offer is that I would say that transmission line siting dockets are probably amongst the most difficult question that the commission has ever asked to decide on. I know that these cases weigh on staff personally, emotionally. I mean, I've seen the impact that these cases have on on our staff when, when we go to those public hearings and talk to landowners for 4 or 5 hours and answer their questions. Our staff has put in, a lot of time trying to understand people's concerns and do the best that we can. I think we've done an admirable job where we can. I just think it's a very difficult question that, to quote Mr. Hanos in our personal conversations, we don't choose winners in these line citing proceedings. Unfortunately, we choose losers. We choose amongst, or that's what the commission ultimately does. We're just a part of it. But we choose amongst a series of very difficult decisions. And unfortunately, beneficial energy infrastructure that's going to benefit the state as a whole is going to harm and is going to impact the individuals and the areas of the state where that infrastructure is sited, and that's just the reality of the situation. And I mean, it's difficult. If the commission were to either deny this permit or were to come up with a series of conditions that say, this transmission line cannot go through the Flint Hills, it cannot go through the area that is defined as the Flint Hills, come up with a different route. Or if it says, due to, given the considerations and the concerns that the commission has, this line has to follow existing transportation corridors. And that's all there is to it. That's what the transmission line siting permit would be. Then, I guess the parties will have to respond to an order like that. And I think Evergy would probably try their best to meet the conditions that the commission placed on the line. But if it ends up, increasing the cost of it significantly or delaying the permit, then it would probably have to be reevaluated by the SPP board. And, who knows what the result of that would be, right? It could be a different project through a different part of the state. It could be, depending on how long it takes, who knows, right? It would be speculation to say what the result of that would be.
Yeah, but one of the untoward aspects of this is trying to evaluate the consequences of line delay and juxtapose that against the permanent harm that's caused by not entertaining other alternatives. That's a big concern to me. And I am not convinced that some of the alternate routes that I think are out there, are available, have been considered. Notwithstanding, I think some of again, if you have an increase in cost, you're balancing against the cost you're imposing on and the harm you're causing on those who have pre-existing rights in property. It's a difficult balancing proposition.
Yeah, I understand. I mean, there's certainly not a lot of easy answers in a proceeding like this.
All right, thank you, Justin. No other questions for me.
Okay, thank you, Commissioner Keen. Commissioner Keither, do you have anything for Mr. Grady?
I don't, but I want to thank Justin for his input. It's been helpful. Thanks.
I also do not have any questions for you, Mr. Grady. As I mentioned, I will provide an opportunity for cross by the parties, but I want to clarify one thing here. And I apologize, Mr. Zakura, if I didn't catch what you were getting at. But there is a limited scope of cross that I'm going to allow. And I'm only going to allow cross-examination from the adverse parties, meaning parties that were not part of the settlement that staff signed on to. So I'm not going to allow friendly cross from SPP or Evergy. My intention was to only allow the landowner interveners and the oil and gas interveners. to ask questions. And so, Mr. Zakura, if that's what you were getting at, that is a limitation that I plan to place on it. So if you do have questions, this opportunity is just for Mr. Zakura and Mr. Buck. So, Mr. Zakura, do you have any questions for Mr. Grady?
I do not, Chair French.
Okay. And Mr. Buck, do you have any questions for Mr. Grady?
Chairman, I do not, but just to place on the record, well, I guess we're good. You kind of took care of it there. But I do not have anything for Mr. Grady. I apologize. Thank you.
Okay, very good. Well, with that, staff, I'm going to assume you don't have any redirect based on Commissioner Keene's questioning.
That's right. Thank you.
Okay. Well, with that, Mr. Grady, we do thank you for your testimony, being able to pop up on the stand at a moment's notice. But I believe there are no more questions for you, so you may step down.
Thank you.
All right. We have come to the conclusion of all the witnesses scheduled for today's hearing. As a reminder, we do have a briefing schedule. We have initial post-hearing briefs set for April 6th, 2026, and we have post-hearing reply briefs set for April 13th, 2026. Let me ask at this time, are there any final concluding matters the parties wish to raise before we adjourn the hearing? Okay, not hearing any. A reminder that a commission order in this docket is due by May 13th, 2026. And if there are no further matters, we will close the record and adjourn. Thank you all for your participation today.
Your Honor, Mr. French, I was asked, when I filled in, I was asked to get copy orders on the record. So if you can help me with that, I would appreciate it and stay on the record until then.
Okay, certainly. We're still on the record. Which parties, I might turn to Evergy first. I think usually they ask for an expedited copy. But can the parties address whether they need copies? I know there will be one coming to our agency.
To the KCC?
To the KCC.
Okay. You get the original then, is that, or?
I believe so. I may turn to Evergy to see. Sometimes they have arranged the court reporter and they ask for that. Mr. Bailey,
yeah. I thought last thing I heard we'd have it by tomorrow, but we had the hearing, and the extended. So I'm not quite sure how the.
So after they asked me to fill in and did not tell me that it was an expedited job, and I said yes. Then they told me that it would be due by end of day on Thursday. So.
Mr. Bailey, is that reasonable to you? That still gives you 2.5 weeks in between this coming Thursday and your brief being due on April 6th. Is that workable?
Yep, sounds like the best we can do anyway, so works for us.
So I'm not sure who's speaking, but that Mr. Bailey is ordering a copy or the original.
I think I represent Evergy. I think we probably get the original.
Okay, thank you. I'm sorry, I have no information about parties or attorneys, so I'm really winging it here. I'm sorry.
This is the blind leading the blind because I don't set any of this up. Mr. Fedotin or Mr. Kimbrell, do you know who arranged the court reporter?
It was us.
Oh, okay.
Yeah, Evergy arranged the court reporter.
Okay. And how does that normally work, Mr. Fedotin, with getting it to us and getting the transcript distributed to the parties?
We get a copy. Evergy's paying for it, and I believe that any parties that want a copy should ask the court reporter for one and make arrangements. And I think they could do that on the record now.
Okay,
that would be great. Thank you.
I mean, they'll eventually be available through the commission's you know, through the docket, but I'm guessing the parties are not are going to want them ASAP. So I would, you know,
Yes,
they're
if
free
they
to
get
do
'em-
whatever they want, but they probably should order one.
If they get them through us, they're not going to have them in time for briefing.
Right.
So, Mr. Zakura and Mr. Buck, are you requesting copies of the transcript as well?
This is Jim Zakor on behalf of the interveners. Yes, we requested a copy, Chair French, but we just wanted ordinary course. We didn't request expedited.
Okay, thank you.
Yes, ma'am. This is Paul Buck, attorney for the oil and gas intervener, and I would like a copy as well, and I do not need that expedited.
Okay, thank you.
Ms. Bates, this is Heather Starnes with Southwest Power Pool, and we would request a copy non-expedited as well, please, ma'am.
Okay, thank you.
Madison Hain on behalf of commission staff, and we would request the same, a copy, but not necessarily on an expedited basis.
And I'm assuming here that these are all electronic copies.
Yes.
Yeah.
Yes, ma'am.
So
Yes, ma'am.
hopefully the court reporting company has y'all's email addresses too. So, okay. Anyone else on copies?
I believe that was all the parties. And then there'll be one coming directly to the agency as well.
Okay, one coming directly to
The KCC. And
KCC.
Brian, do you usually receive those?
Sorry, I was on mute. They can. I think we can send it to Tristan, but or me, but
Okay. And that does not need to be expedited.
And Ms. Bates, if you could put your email address into the chat, I can send you an email so that you have my email address. This is Tristan Kimmerell. I'm the Assistant General Counsel.
Okay, that would be great.
Thank you.
All right, before we close the Zoom, Tristan, I just want to confirm that you got that email out of the chat.
Yes, I do. Thanks.
Okay, any further matters before we close the record and adjourn? Okay, hearing none, we are adjourned. We thank you all for your participation.
Mr. French, could I, and not on the record, but could I just verify some spellings with you maybe?
Certainly, certainly.
Okay, there was a Mr. Haynos referenced.
Haynos.
And a Mr. Galino.
And I can send you a document that has all those names listed if that would be easier,
Okay.
Ms. Bates.
Okay, that would be perfect. And when we talked about the Branson 345, was it KB as in boy or KV as in volts?
Volts,
Okay.
kilovolts.
Volt. Okay, that's what I thought, but I want to make sure. And Mr. Lovelace, is that in the information you're sending me?
Yes, it will be.
Yeah.
Okay,
That's
perfect.
It's an agenda document that lists all of the witnesses.
Oh, perfect.
And counsel for all the parties.
That would be so awesome. And does it have like your case name and all that good stuff? Okay, I'm sorry. I don't usually go into this totally empty-handed and blindfolded too. So thank you. Thank you so much.
Yes. Anything further?
I don't think so.
Okay.
If I
Very
do,
good.
I'll have the other gentleman's email. So
Yes, yes. As long as you've got an email from somebody with a ks.gov end to it, I suspect you can track down the information you need. Thank you very much for helping us out on short notice and getting us through this. It was very helpful.
You bet. You bet.
All right. If there are no other final matters, we will go ahead and close the Zoom. Thank you all.